court pleases myself and Advocate Banda PF participate. The name is G. Banoy.
As the court pleases your lordship, I still confirm the representation of accused 1 to 4. Advocate TFO instructed by TT Tobani attorneys.
As the court pleases my lord, I confirm that appearances on behalf of accused 5 are as before. The court pleases.
Yes.
As the court pleases my lord, the matter has already been postponed to the 5th of September 2022 for the continuation of the proceedings. Today was set aside to hear submissions on 2 interlocutory issues that Advocate Tifo raised, namely the issue of jurisdiction and the second issue pertains to the 2 dockets. First one is cast 636 of 10 of 2014 and 375 of 1 of 2019. The court set a timetable for the filing of the heads by Advocate Tifo and the period within which the state and Advocate Nshololo had to reply.
Yes.
However, my lord, no heads have been received from Advocate Tifo on those 2 aspects. Therefore, the need for the state and Advocate Nshololo to file his fell away. We received a series of correspondence, and I will with broad strokes deal with the timelines of the correspondence.
But before you do that, because I recall we had 2.5 days of hectic address amidst warning that Advocate therefore should forsake that and go the route of filing heads.
Yes.
And I also indicated that otherwise whatever was happening was just a waste of time. I cannot put it better. It's a waste of precious time under circumstances where all of us were sounding agency in this matter. Now you are saying no heads, and indeed on my table I was to ask all the 3 of you about the heads, because also on my table nothing came. And when we are in court, all of us are sounding agency, extreme agency, and I agree in this matter there is extreme agency. And that is why we set time for everyone to do as they had to do. Even if anybody did not do anything, I expected communication from all of you about where we are at. Even if no heads were forthcoming from anybody, I needed to be placed in a position where I know what is happening. So I don't know what is happening in this trial, because I have to come here today and be told as I'm being told, and it's you speaking, Advocate therefore who should have started the ball running. I have not heard of from anything from him.
As the court pleases, I'm just setting out the background. Advocate Tifo has indicated that would like to address the court, just giving the background, my lord, of where we are.
Advocate Tefo.
Yes, Lord. I think Advocate Baloyi was supposed to finish the background. I agree with him. He has to lay the background. Then I'll come.
Which background?
Because I'm going to also ask, after they finish, I'm going to ask the court to give me 30 minutes for consultation with my client, because they just arrived now, 2 of them.
No,
I
you're
still have to
talking
consult with them.
consultation. I'm talking heads that we set dates upon. I'm saying, fill me in. I don't just jump on top of something that has not been completed. Fill me in what is the position with those heads. Now you want me to listen to him on top of something that is outstanding. What kind of proceedings do you want us to run?
I don't know, Your Lordship, but I'm saying, by Advocate Baloyi, we discussed about this. He was right. I support what he's doing now. Then
No, I
after-
don't support it, because there's a matter outstanding of heads that I set head. When the court set dates about things to be done, whether it's done or not, we should pass on that with an explanation. Now you have determined that you prefer Advocate Baloyi to address me first, before you address me about something about which we made notes and agreed that on this and that date there will be heads. And I'm saying, fill me in, even if it's a brief filling in about what is happening. How do I record things on top of each other?
Your Lordship, this day has been agreed upon, and it's not true that in the interval from that day of postponement until today, there hasn't been anything that was happening to update the court and my colleagues here. It's not true, that one. The fact of the matter is that I've indicated, there were correspondence that taking place amongst, generated from the accused 1 to 4, updating the court insofar as our last agreement regarding the jurisdiction issue.
Do you have a copy of that correspondence? Because I didn't see that correspondence.
Your Lordship, let me finish.
Yeah?
You'll know when I finish. But if you interrupt me, you won't know. Just give me an opportunity. We're still having the day until 3:30. We're here. So, I still reiterate that I think this is a protocol, and the right protocol, because the matter belongs to the parties, to the state and the accused, not to the court. The court has to listen what the parties have agreed upon.
No.
There is agreement.
The court
but
has to direct these proceedings. I cannot hear from the two of you. I have to direct my proceedings the way I know proceedings should run. And you cannot tell me how I should proceed, I should direct those proceedings. And I have told you, I need an explanation. I don't want a full explanation. I want to be told what is the position about the heads I expected, which I don't have on my table.
Exactly.
Even if it's one sentence, but I need to know what I'm doing so that the process is clear on my side. Not the way you want it, the way I will be able to handle it from my side.
The problem will be one, Your Lordship, with the due respect and your honorable self, Justice Maumela. If the party, the accused party, 1 to 4, want to say something, is not given opportunity, you are going to get the explanation why there are no heads, not even a page, not even one sentence.
I'm saying give me an explanation about whether I'm still to receive heads or whether I am to go over that process, because on my side, I'm waiting for heads and they are not here. That's what I'm saying.
There is a new, there is a latest development, so to say. There is a latest development. On the 29th of June, I met my learned colleague, Advocate Baloy. We have a discussion at his office here in Pretoria. And our discussion was very fruitful. That later came up with a new development whereby accused 1 to 4 years. We then submitted application or representations in terms of the provisions of Section 6B of the Criminal Procedure Act 51 of 1977 to the NDPP. And I also sent it, I copied the court, I copied Mshololo, I copied the state, and then I also got acknowledged of receipt by the state. And we also discussed last week the latest development. I was told that Section 6B is getting attention. And even this morning, I was also updated that Section 6 is getting attention. So I gave...
Yes, that is the explanation I needed before I listened to him. So I am no longer...
But to bring this explanation before he is finalized, it will be putting the cart before the horses.
For me, there's no cart before the horse because
We
I
may be
needed
different.
this explanation, and you have given me that explanation. Now I will listen to Advocate Baloy.
Yes, and I would later, maybe if you may be finished before I address the court, I still need to address, to consult with 2 of my clients, because when the court came here, 2 of my clients were not here yet. They just came the same time with the court. I would ask 30 minutes before I would do my address.
Advocate Baloy.
As a confused, my lord, I was in the process of dealing with the correspondence that has been received from Advocate Tefo on the 18th of June 2022. A request for further particulars was received from Advocate Tefo. The court was also copied, to which the state responded on the 20th of June 2022. Then on the 30th of June 2022, Advocate Tefo responded to our letter of the 20th of June, indicating that his correspondence was directed to the investigating officer.
When was that?
On the 30th of June. Indicating that his correspondence was directed to the investigating officer and the National Commissioner, and that he expected a response from them. Then on the 30th of June 2022, another document with a caption, "Interference with prosecutorial independence," was received. And in paragraph 1 of that letter, the issue of jurisdiction, it's mentioned that the issue of jurisdiction is no longer an issue. And furthermore, he signaled his intention to bring an application in terms of Section 6B of the Criminal Procedure Act to the National Director of Public Prosecutions. And that was further confirmed in paragraph 14 of that correspondence.
Yes?
Then on the 4th of July 2022, a document with the heading Request for Reasons for Not Prosecute in Force Lawyers Cast 375 of 1 of 2019 was received. Then on the same day, the 4th of July 2022, another correspondence with the caption Representations in terms of Section 6B of Act 51 of 1977 was received. And in paragraphs 117 to 118 of that correspondence, Advocate Tifo mentioned that the defense has since abandoned the issue of jurisdiction and has resolved to bring an application in terms of Section 6B of the Criminal Procedure Act. Now, as confirmed by Advocate for himself when he was on the floor just a few minutes ago, the issue of jurisdiction has been abandoned. And my Lord will recall that would have been the main reason why we would reconvene today, or part of the reason why we would convene today.
Yes?
Now, my Lord, insofar as the second issue is concerned, pertaining to the two dockets, as was just intimated, he has submitted representations to the Office of the National Director of Public Prosecutions. On the 4th of July 2022, and we'll have to await the outcome.
An outcome from the prosecutorial authority.
Yes, from the NDPP. And my Lord, we respect the process that Advocate Tifo has chosen, but, and this is no criticism to him, and we see in this with the greatest of respect. The DPP Pretoria is the one who took the decision to institute a prosecution in this matter, and this representation should have been made to him, but as I mentioned, we respect the route that Advocate was taking. And in terms of Section 179 of the Constitution, the NDPP has the power to review the decision of the DPP to prosecute or not to prosecute after consulting that particular DPP, or to intervene if policy directives have not been complied with. Now, my Lord, I'm mentioning this because the route that the representations will travel will amount to the following. There will be a consultation process between the NDPP and the DPP Pretoria.
Yes, please, the court. Thank you, Your Lordship. I think my learned colleague is now jumping out of the pot, getting to the fire. We've agreed, and you want to prove to me that he's not trusted. We have approved, we have spoken, and agreed up to where he will engage the court. I was of the view that when he addressed that the Section 6B has been submitted and it's getting attention, that's where he will stop and introduce me to the court. So what he now want to jump into is putting the cart before the buffaloes.
Advocate Baloi?
I apologize for Advocate Divo. I was just merely explaining the process, my lord, that the representations will follow, and that will also take care of the issue as to more or less when the response can be expected. I was just merely outlining the process, my lord. But if Advocate Divo was to come in now, by all means.
Yes?
Yes, that is please the court, Your Lordship. That process, I'm not denying it. I say it will come later. So now, Your Lordship, before I address the court, I request 30 minutes. I want to meet 2 of my clients. Then later we can address the court with the proper mandate.
Advocate Baloi?
There's no objection to the request.
Advocate Nchololo? There's a request for adjournment for 30 minutes.
As the court is, I have no objection.
take it forward. I think it will be perhaps improper for the letter now to be read without the head of prison having been notified of perhaps the adverse or comments that might be adverse to the prison authorities. We submit that they need to be given a reasonable opportunity to consider the contents of the letter, and once that has been done, my lord, perhaps at that stage we can then discuss as to the way forward. I think that is the normal process, my lord, that if there's anything adverse against any person, they should be given an opportunity to comment before further action is embarked upon. Please.
Please, the court, Your Lordship. I vehemently disagree with the proposal by my learned colleague, the state here. That letter, accused number 3, has discussed that letter with the prison authority. The reason today he was so late to be here, most of the time, accused number 3 is the first person here. The reason he has been late is because of this letter. And this letter has been a subject of discussion for many times. Actually, not only that contains that, the contents, as the previous time, they've been the subject of, they've even been the subject of this court. I wouldn't understand why would my learned colleague be concerned about the adversaries that may be in that letter. Accused number 3 is already, I once said, it's on record that if this court cannot be expeditious, it may be possible that when this court or this matter, this trial finalized, accused number 3 is 6 feet under. So he has suffered enough. He even informed the court, the prison, that today I'm going to make sure the court understand my plight at this prison. So you cannot now that the head of the prison must be here. When it suits him or her and fearing the adversaries in the letter, it cannot be. And Your Lordship, it has been said previously, we requested that during the time when we were still this discussion of the prison condition of accused number 3 was so fashionable. There was a stage whereby I requested this honorable court if they can summon the head of the prison. The head of prison had the opportunity to come here and to respond to the allegations which were made against that prison, insofar as the condition under which my client was subjected to. So it cannot be the state that the prison must be here when it suits them. No, we refuse. This letter has to be direct to the court. And instead, actually, when that opportunity was there for the head of prison to come here and relate the inhuman condition under which my client had been subjected to, didn't come. Instead, he or she, I say who he or she because I've made to understand the situation of management in that prison, that there is no permanent head of the prison there. It's like a Hollywood, there are actors there. Sometimes there are 2 women who are acting as the head of the prison.
Advocate, therefore, I think this is where we differ all the time. You give me evidence from the bar all the time. The issue we have here is whether the letter should be read or not. Advocate Baloyi has sounded opposition to that being read, saying that the prison authorities should be engaged first. Now you are giving evidence.
I don't know. I mean, when I have to respond or reply to the allegations, it will be that I'm giving the evidence from the bar. And it will always be me, accused number 1 to 4, giving the evidence from the bar.
It is because every day you do it, and I'm saying...
I'm even relating the history.
I'm saying you requested for the letter to be written.
Yes.
He has objected. Can't you give me an opportunity to listen to Advocate Mshololo and then decide whether the letter can be read or not?
No, I cannot listen to Advocate Mshololo because he's my client. It's not Advocate Mshololo's client.
You can
doesn't
plug your eyes, your ears. I will listen. I want to listen to Advocate Mshololo. She's part of this trial, and she will not be left out on any step of this trial. Otherwise, I'm running straight into a mistrial.
Mshololo is so lucky, Your Lordship. Okay, thank you.
Yeah. And you are so lucky because you are pulling this court to and fro as you like, as if we are here at your mercy, and we are not.
Thank you, my lord, for the indulgence of the court. My lord, I object to the reading of the document into the record. Firstly, my lord, the reason being that when the document is about to be read into the record, firstly, it has to be shared amongst all the counsels who are involved in this case. And in this document, it has not been either submitted to us or shared with us. And secondly, my lord, for the letter of which we don't know, we're just assuming that it's about the conditions of inhuman behavior that is happening.
Wait a bit. You are saying you are not aware of this letter?
Of this letter. We're not aware of this letter, and no copies have been submitted to us. And now it is about to be read into the record when we have not had sight of that letter, so that we can be able to prepare ourselves to respond at the end of the day. And secondly, my lord, even if that letter was about to be read or to be dealt with before this court, the procedure that has been set up by this honorable court on the previous occasion when the same incident was reported, it's that it will not serve any purpose if a member or the head of the correctional service department is not summoned to be present in court so that he can be able to respond. So the issue of reading these conditions without that letter being shared with the department and also with not being shared with the state is not going to serve any purpose before this court, because there is no decision that can be made on that application or on that note without the response from the correctional. I therefore submit, my lord, that we follow the same procedure if we are all willing to fast-track the trial and not waste the court's time on something that is not going to be finalized today without the response from the relevant people. Secondly, my lord, after that, I have a problem, my lord, that I have not responded to the purpose of the sitting of this court today. When this court was adjourned, my lord, we were ordered to respond on the 30th.
Objection, Your Lordship.
Overruled.
That's the court process. We were ordered, I was ordered, my lord, to respond by filing the heads of argument to this honorable court on the 30th of June. My lord, I have not been able to comply with the court order because that was a directive from his lordship. And the result being that it's because I had not received the heads of the arguments from the applicant who had intended or who had proposed to bring an application. And as a result, I was unable to respond. I apologize, my lord, for not communicating such non-compliance with the court or the registrar. But I was hoping that maybe the heads will be filed even later than the dates that were ordered. As a result, I was unable to file and to comply with the court order. Being that as it may, my lord, I submit and I request this honorable court not to entertain any application today. The purpose for today's court sitting was to deal with the issue of jurisdiction. And the order was made as to how the issue of jurisdiction will be dealt with today. And none of the directives of this honorable court were complied with by all the parties, including the applicant himself. So the purpose of sitting today was to listen to the application of the jurisdiction. And the applicant, which is my learned friend, had decided to abandon the application of jurisdiction. If the application of jurisdiction has been abandoned, my lord, therefore there is no purpose, there is no reason for this court to continue sitting and listen to any other application. The issue of representation to the NDPP and any other issues through the communication that have been communicated and served to us is not the matter for this court to deal with today. If there are any representations that are still outstanding or that are still being engaged between my learned friend and the state, it should not crowd these proceedings today. The purpose has fallen away, my lord, and I ask that this court be adjourned to the date that was supposed to be sitting, because there is no proper application, there is no proper heads of arguments that has been placed before this court. Any complaints of ill treatment or any complaints or any subsequent application cannot be entertained, my lord, with due respect at this particular time, because I am the one who is still on the platform to continue with the cross-examination, my lord. And we had respected the court when this matter was adjourned, was given an opportunity in between before the next remand date for the purpose of entertaining the issue of jurisdiction. Now that the purpose of jurisdiction has fallen away, my lord, I submit and I request that this court needs to be adjourned to the 4th of September so that we can be able to proceed with this matter. If we are going to entertain multiple applications that are coming in between whilst I'm on the floor, my lord, I submit, my lord, that is not the correct and the proper procedure to be followed in a criminal trial. Until I finish with my cross-examination, my lord, as I've submitted before, then any other subsequent application can be entertained after I have finished with my cross-examination. Those are my submissions, my lord, as the court pleases.
Yes, I think, Advocate Mshololo, you started where I started this morning.
Yes, ma'am.
That we should lay the matter of heads to rest. And when Advocate Baloyi gave me an explanation about further communication, I thought it is something to which you are privy. But you did hear me say that we have to deal with the issue of heads that should have been here, and you had the explanation given by Advocate Tefo.
Yes,
that
ma'am.
after we painstakingly endured 2.5 days of time wasting,
Yes, ma'am.
until we insisted on heads, he went and abandoned that application. I have my own suspicion about why it was abandoned, but suspicions don't carry
As the court
in
pleases.
at court. But then the issue of the letter, the reason why I was about to have it read was because I took it that Advocate, therefore, being an advocate, will not be forwarding anything to the court without getting his colleagues to be privy to the contents, because that is how it happens every day in every court in the Republic.
As the court pleases, ma'am.
Now I'm hearing from you. That's why I had to ask you again that you do not know what stands there.
Yes, ma'am.
That is the first issue. I agree with you that I've made a ruling that nothing shall carry before you are done with cross-examination.
As the court pleases, my lord.
And that is the position I still have.
Thank you, my lord.
But there's a point on which you and me differ.
Yes, ma'am.
And that is where it regards the well-being, if not the survival, of any of the accused. When that is raised, I cannot brush it off
Yes, my lord.
my desk because in the history of this country, things happen in prison.
Yes, ma'am.
And in the history of this country, mortuary vans drive into prison
Yes, ma'am.
when they should not have driven. So safe to agree with you that you should be privy to what stands in the letter before I listen to anybody. I don't agree with you that we should not devote time, however little, however plenty, to hear the issue about the safety or the well-being. Well-being is even an understanding, the safety or even the survival of any of the accused in this case, whilst they are at any prison. What will be wrong, though, where I agree with you, will be for this court to then act on what will have been contained in the letter without listening to the prison authority if the letter will be going against them. And I keep on saying, I don't know, for the umpteenth time, I keep on saying, in South Africa we adhere to observance to the natural principles of justice. One of them is audi alteram partem rule. So partly I agree with you, partly I don't. Because where it regards the safety or even the safe survival of any of the people that appear before me, if I get any indication that that is broadly or narrowly brought into question,
Yes, ma'am.
as first as a human being, secondly as this court, I have to devote time to hear what is happening, but having followed the correct procedure in that the letter can never be read into the record before the two of you. As to whether the prison authorities must be here when it's read, that's another matter. I don't really agree. I think what should happen is the court can never then act on the contents of that letter before hearing the prison authorities if the letter will be against them.
As the court pleases, my lord, I agree with his lordship. However, my lord, my request or my submissions, respectful submission is that, my lord, let us deal with one issue at a time.
Mm-hmm.
The purpose for today's court sitting was to hear the issue of jurisdiction.
Mm-hmm.
Let us deal with that, my lord, and then once that is finalized, and then a second application can be entertained or request regarding the condition raised by accused number 3, also following the proper procedure. But let us avoid running multiple issues
Yeah. But
at a time.
must all the accused not still be here or alive when we reach there?
No, my lord, I'm not suggesting
Yes,
that.
please,
I was just suggesting.
May I please, when this has been said, can you sit down? Can the interpreter interpret on this? Because I was still going to ask.
I'm going to listen to her, and then there shall be interpretation.
Please.
No, my lord, I was just addressing that. Let us at least follow the procedure in handling the issues.
Yes.
My lord, those are my submissions, my lord.
Yeah, but what do you say about issues about allegations that suggest life-threatening ongoing against any of the accused?
My
that the court should at least have an idea where it's going. But I'm not there yet because you don't even know what it is. Advocate Baloyi doesn't know what it is. the first I would think is that you should acquaint yourself with the contents, subject to agreement by Advocate Tefo. If he does not want any of you to look into the contents of that letter, then that letter doesn't fly before this court.
As the court, that was my first submission, my lord, that I made to say it cannot be read. The procedure in leading the evidence, it cannot be read without counsels involved in a matter having sight of the content of that letter. It has to be shared with us first before we can proceed with that. Then I moved on to ask that, can we deal with the issue of the purpose of today's sitting, and then move on to the second application as the court pleases me.
I don't know whether we still have the purpose in place from what I have heard. Maybe I heard what was not being said.
As the court
Because
pleases.
I heard repeatedly from Advocate Baloyi issues of abandonment of the aspect of, that's why you even hear me say, because I had, oh, let me be open. I went and revised again Section 110 of the Criminal Procedure Act, which is so clear that we shouldn't have spent 2.5 days here.
Yes, ma'am.
Because it says if an accused has issues with jurisdiction in any given court
Yes.
in the Republic, once that accused, despite the issues that accused has, pleads to the charge put,
Yes, ma'am.
it will, the section reads, it will be taken as if, and I'm putting it in simple language, it will be taken as if that accused has consented
To the
to
jurisdiction.
the jurisdiction. And in this case, we have had pleas.
That's the
We are
standing
past
procedure.
that.
Thank
And
you.
they were not pleas of before court with an unrepresented accused. With legal representation, they were pleas. So that's why I said I don't understand why we went through it all and now it's abandoned after we literally and amidst warning wasted time. But
That's the court pleases.
I think the aspect of those letters, until you read and you give me an indication, I will not be persuaded to ignore. If I do that and we end up, and God forbid, and we end up with a corpse, that corpse is on my judicial lap,
As the court pleases.
and it carries through with me throughout my career.
As the court
And
pleases,
that's
my
not
lord.
anything I want.
Those were my submissions, ma'am.
Okay.
Thank you, ma'am.
Is it true that your colleagues have no idea about that letter?
It's not true.
They know. They have read the letter.
Not letter, but the conditions.
No.
They've been conversed previously.
But I'm asking you about
And
the...
if once in
I'm
my
asking
life-
you about the letter, Advocate Tefo.
Once in the life of this trial,
Yes.
I be given opportunity, let the one representing accused 1 to 4, to say whatever I want to say in relation to the mandate or instructions, I'll be the happiest person. I'm not happy.
Yeah,
Look
but
at
we are
me.
not talking about happiness here.
Look
we
at
are
me, I'm not
talking
happy.
about whether Advocate Baloyi...
My displeasure represents my client.
Can you allow me to finish what I say?
I want to finish first.
Yeah, like you always demand.
All right, continue.
I'm saying, once Advocate Baloyi and Advocate Isholos tell me that they are aware of the contents of the letter you want read into the record, which I was about to allow because I presumed, like any advocate would do, any attorney would do in a South African court, that they are privy to the contents. Is it true that they are not privy to the contents of the letter?
When we talk about the letter specifically, yes.
Yeah, then...
Not the condition.
Then it cannot be read. It cannot be read in this
Which-
court because
Okay.
then it's a conversation between you and me, excluding them. And that's not how court processes run.
Allow me actually, I do not have appetite to reply to what Mshololo has said. I'm just replying to this because you're asking me the question. So, which procedure or which section of the Criminal Procedure Act, when this letter is talking about the conditions of my client, for which are known by this court, it has been canvassed previously, are known by the prison where he is, which section of the CPA or the procedure, it may not be in the CPA, that says Mshololo has got the right, who's got her own client, as a defense. It's a defense of accused number 5. It's a defense counsel of accused number 5. Whatever affects accused number 5, that's the business of Mshololo. So whatever affects the business of accused 1 and 4.
It's not Mshololo alone. Also, Baloyi said the same.
Allow me to finish.
No, you are referring me to, you want me to focus on Mshololo. And I'm saying, when you address me, keep in mind that there are 2 people opposing the reading of the letter.
Your Lordship, when Advocate Mshololo was given that opportunity to say what she wanted to say, I was looking at my watch here.
Yes.
I would look at the time that she was given without interruption. So now, I just want to say something that could have cost us 45 seconds plus. 45 seconds minus.
I am
so
still
now
I am still directing.
You are interjecting now.
There are 2 people.
I don't deny that.
Yes. So
Yes.
I'm saying whatever goes for Mshololo also goes for Baloyi regarding what you are saying. That's all I'm saying.
I was still asking the question as to which section, which provisions of Criminal Procedure Act, or which procedure. It may not be maybe in the Criminal Procedure Act that says, when my client, accused number 3, is complaining about the condition that has been already canvassed before, and today's got a letter, and he informed the prison that today I'm going to make sure that the court hear the conditions under which I'm subjected. And this is a letter he wrote. He took all the efforts to write this letter. So now when I requested this court to say, my client want the court to know his situation at the prison, and this may come through the interpreter, who will even interpret with his language. So where did it come to say, no, Mshololo must know as the accused number 5's client? It's got nothing to do with accused number 1 to 4. Whatever it affects accused 1 to 4 is not the business of Mshololo. My client, accused number 3, was kidnapped from Johannesburg prison, brought to Hoshimampuru, and taken to maximum, worse conditions. Now today can be when you want this court to know the condition under which is being subjected is a business of Mshololo. It cannot be, Your Lordship. Since well, you cannot even take me to the provision of the CPA or any procedure. When I have to address the issues about my client, it will always be, it's become a norm now to say procedure. Which court am I attending? And Mshololo is attending. Which school of law did I attend? Mshololo did not attend.
I've been wondering about that. You know?
Yes.
I have really been wondering about it. I have been, you know, to an extent of wondering whether it was day or night school. You know, I have really been wondering.
Yeah.
A simple issue of sharing information. Now you are ranting about it as if it's something unheard of.
The cat is out of the bag today. I'm happy. The cat that has been on the bench is out of the bag today. You have been wondering about me.
Yeah.
I'm not surprised.
These are the procedures you want to impose here.
But I cannot be told.
I've been wondering.
But I cannot be told about the provision or the procedure. Then I'm saying, yeah, it's my client is suffering. Now today,
you will say,
today we've been taken.
You ask the question where it's found. Now, before you give anybody the opportunity to I nearly said inform, to educate you
It's not fair.
about where it will be found. You are declaring that you have not been answered. Address, and they will tell you. I can also assist in educating you.
I've been always saying, I accept your education, and I've been looking forward to your education, where somehow out, then you have to rein us.
Yeah.
But now, this reining, it has been so discriminative. Always. And I've been wondering. And I'm happy the cat is out of the bag, that you wonder which school I've attended.
Yeah,
Yes.
I'm really wondering. You raised the question. I said it is not only the honorable advocate therefore wondering about schools. It is also me
Yes.
wondering about schools because of the procedures you try and time and again try to impose on this court. It's
Yeah.
based only on the procedures you try and run before this court, which makes me wonder, because it's not there in the Criminal Procedure Act, it's not there in any writing or any court.
Thank you, Lordship. Let's cut to the chase. Can I consult with my client, accused 3, if it's amenable for anybody to lay his or her eyes on his consent? Can I
Okay.
approach him?
Advocate Baloy?
As a court cases,
It's about
the
him
request,
wanting
yeah.
opportunity to consult.
We don't have a problem with that, my lord.
Advocate Msholol?
I have no objection, my lord.
Thank you, Lordship.
How long?
No, it's not. It's the longest is a 60 second.
Okay.
Thank you, Lordship. It was not interpreted, and I don't know how are we going to cross that.
Mr. Interpreter?
All that has been said, it was not interpreted.
If I interpret, my lord, can I make a request to the court, my lord, to the court? The way, and it's always been coming from the defense side. It's as if now I don't know when to interpret or how to interpret. The defense would go on and on and on and on. As court officials, they should know. You speak and you stop. You speak and you stop. They go on. So I don't write everything. When it suits them, they stop and say it must be interpreted, as if I don't know when to interpret. Can the court just assist me there, my lord? Because now I end up not writing everything that they are saying. So if, as it is done when a witness is here, you speak, you stop, and then the interpretation. Now it would seem to the accused I don't want to interpret, whereas the defense takes the whole day to speak and expect me to interpret. Can I please ask the court to assist in that regard?
Mr. Interpreter, I have always been praying almost that this doesn't happen. The last thing that can happen is for you to lose your patience. This is court as presented by the 4 of us. It may be very unlike anything you have experienced, but now you are requested to interpret. And I'm giving you the opportunity, and maybe also saying, to the extent that I also might have contributed in you not getting comfort from the process, we apologize. But it's the time now for you to interpret so that we can move forward.
Your Lordship, coming in there, I honestly agree with the interpreter, because as I said, I don't have an appetite
But
to further.
won't you let him
respond to it.
interpret and we move forward? For God's
When you
sake,
say the defense,
let him interpret and we move forward.
Let me
Whatever
finish.
you have, you will say it when you rise.
no, that's the
Please
time now.
let him interpret. Please, again,
before you can
I don't know
start.
for how many times, sit down so that he interpret. Please, advocate them.
All right, it's fine. Let me go to my client.
Ngizokhumbula ke bemnumzana ukuthi isizathu noma ke injongo yokuthi icala lehlehliselwe namuhla bekunodaba ke olwavezwa ke uyena ke ummeli.
Sorry, Mr.
Okay.
Sorry. Thanks for indulgence, Your Lordship. I consulted with accused 3. He said is for as long as his desire will be done accordingly, he's amenable to my colleagues to go through it. Thereafter, it can be handed over. They can go through it. Don't know whether it will be in the sense of one by one or ask the court to do the copies. Actually, I think the copies will be viable solution.
I think we'll request the secretary to generate copies
Yes.
whilst he does the interpretation.
My proposal is that, yes.
Becala ke lihlehliselwe namuhla ngenhloso ke noma ngalokho kwavezwa ke udaba lavezwa uyena ummangalelwa wokuqala ukuya ke kowesine ukuthi ke icala kwangafanele ukuthi liqulwa noma lilalelwa kuyona lenkantolo. Olwesibili ke udaba kwayidokodo noma ke alamadokodo amabili u63610 ka2014 kanye ke no3751 ka2019. Inkantolo ke yanikeza ke isikhathi ngizokhumbula ke ngelanga lahlehliswa ngalicala ukuthi ke ummeli wabamangalelwa laba abaneke uzothi ke kube uyena ke ofaka ke amaphepha akhe eletha leso sicelo kwaze kwanikezwa nesikhathi ke futhi la kwakufanele khona ukuthi umshushisi kanye naye ke ummeli kamangalelwa wesihlanu ukuthi baphendule. Kodwa ke umshushisi uthe masetshela inkantolo ukuthi ke akunalutho olwenziwa kuso sonke lesi sikhathi uyena ke ummeli wabamangalelwa abane, ingakho ke bengakhonanga yena ke kanye naye ke uadvocate Mshololo ukuthi ke baphendule noma kube khona abakushoyo kuyona lenkantolo. Yabe inkantolo ke isingenelela ke isikhuluma ke yathi inkantolo noma ke ngaso sonke isikhathi noma wonke umuntu obandakanyekayo kulecala inkantolo abameli kanye naye umshushisi ngaso sonke isikhathi uma bekhuluma ke wonke umuntu ugcizelela ekuthini lecala leli ke alisheshiso noma ke aliqube ngokusheshayo. Kodwa ke inkantolo ayinalutho noma ayinawo amaphepha aphambi kwayo nanjengoba kwakuvunyelwene ngelanga lokugcina inkantolo ihlezi. Yabe ke inkantolo isimcela ke yena ke ummeli wabamangalelwa abane ukuthi ke ayitsheleke noma ayazise ukuthi nanjengoba sila namuhla kwenzekani ke wabesesho ke ummeli ukuthi cha akulona iqiniso ukuthi akunalutho olwenzekile. Kukhona ke okubhaliwe yabe singenelela ke nala inkantolo isho khona ke ukuthi inkantolo ifisa nje yona ukwazi ukuthi yini eyenziwe sesizofikelela khona la. Ummeli wabamangalelwa abane ke usitshelile ke inkantolo ukuthi ke khona ke okwenzekile ngokuthi nge-29 zika June kuwona lo nyaka wahlangana naye uadvocate Baloyi wabeke la khona ke esemchazela khona ke ukuthi abasaqhubekiki ngodaba lokuthi icala akumele liqulwe kuyona lenkantolo kodwa ke sebezofaka isicelo sakhe usection 6B la khona ke uthe umebhalela yena ke uadvocate Baloyi wabe nayo ke inkantolo kanye naye ke uadvocate Mshololo ebathumela ke yona leyo ncwadi leyo. Futhi ke kwiviki lendlule uphindile futhi wakhulumisana naye ke uadvocate Baloyi wamtshela ke ukuthi empeleni ke lo section 6B lowo ke unakiwe noma kukhona ke okwenziwayo ngako lokho. Wabe secela ke isikhathi ukuthi ke ngaphambilini nje ukuthi iqhubeke wacela isikhathi ke sokuthi akhulumisane nabamangalelwa ababili abangene emuva kwesikhathi nje ngaphambilini kokuthi inkantolo ke iqale. Phendulile ke uadvocate Baloyi wathi nge-18 zika June 2022 kunesicelo ke esafika ke noma ke awasithola sisuka kuyena ke uadvocate uTifo efuna ke eminye imininingwane mayelana nalo icala. Nge-20 zika June 20 kuyona lo nyaka baphendula ke bewumbuso kuleso sicelo leso nge-30 zikaJuni 2022 wasephendula-ke u-advocate Tifo noma ke ummeli wabamangalelwa abane ephendula kuleyo ncwadi-ke eyabhalwa nge-20 zikaJuni 2022 ukuthi yena-ke leyo ncwadi leyo ayeyibhalile wayeyibhalele umphenyi noma ke umseshi walo icala kanye futhi no-commissioner wamaphoyisa. Ngakho-ke impendulo ebengayilindele kumbuso noma ke kubeshushisi kodwa ebelindele kulabo ababili ayebabhalele. Futhi-ke kuphindile kwabhalwa-ke nange-30 zikaJuni yena-ke ummeli wabamangalelwa abane esechaza-ke ukuthi akuselona-ke udaba lokuthi icala leli liqulwa kuyiphi inkantolo. Ziwu-4 kuyona le nyanga uJulayi 20 kuyona lo nyaka esikuwona-ke uphindile futhi-ke ummeli wabe esebhalela wona-ke umbuso echaza-ke nala ukuthi-ke lesa sinqumo sangaphambilini-ke abasaqhubeki ngaso kodwa-ke sebemanje befaka isicelo sakhe-ke usection 6B. Injongo-ke noma inhloso yokuthi-ke siqhubeke noma sibe khona la bekungamadokodo amabili kwakunye futhi-ke ikhona-ke nencwadi ngokusho kwakho umshushisi efakiwe noma yafakwa nge-4 zikaJulayi 2022 ifakwa-ke kulona-ke ihhovisi lekuyena owengamele noma ophethwe ezokushushisa. Futhi-ke kuzofanele ukuthi kulindelwe-ke imiphumela-ke ukuthi bazophendula bathini kuleyo ncwadi leyo. Uthe-ke uma ngabe u-advocate Baloyi esezama-ke ukuthi aveze udaba lokuthi-ke wayichaza-ke ukuthi-ke abeshushisayo la ePitoli yibona abathatha isinqumo sokuthi akushushisweke kulona lecala leli ukuthi-ke kuzoba khona ukukhulumisana-ke phakathi kowengamele ezokushushisa kuzwelonke kanye-ke nalabo abashushisa la ePitoli. Yila khona-ke esesukuma khona-ke u-advocate uTefu-ke wathi-ke cha uyamcela-ke ukuthi akangabi saqhubeka-ke ngalokho. Phindile-ke futhi wabe secala leso sikhathi-ke ila inkantolo imnikeze khona-ke isikhathi sokuthi-ke kahamba yokhulumisana nabo. Kwase kunikezwa-ke u-advocate Msholo isikhathi-ke sokuthi akhulume naye washo-ke ukuthi cha kudaba-ke oluye lavezwa-ke ukuthi akube nale ncwadi kaMmangalelwa wesithathu efundwayo khona la enkantolo. Isicelo-ke bekuwukuthi-ke kube uyena inkolika oyifundayo. Impela-ke inkantolo iye yavuma-ke kodwa nje ngaphambilini kwalokho yafuna-ke ukuzwa phakathi kwakhe u-advocate uBaloyi naye u-advocate Mshololo. Washo-ke u-advocate Mshololo ukuthi cha yena-ke leyo ncwadi leyo bekufanele ukuthi iqala-ke ngaphambilini kokuthi yafundwe enkantolo ibonwe-ke uyena nanjengoba emele ummangalelwa wesihlanu kanye naye-ke umshushisi. Yebo-ke singacabanga nje ukuthi-ke imayelana nesimo sokungaphatheki kahle kwakhe ummangalelwa wesithathu ejele. Kodwa-ke thina-ke asiyazi ukuthi yini ebhalwe lapho futhi-ke asisitholanga isikhathi sokuthi silungiselele futhi siphendule kuyona leyo ncwadi leyo. Noma ngabe-ke ingafundwa-ke leyo ncwadi leyo akukho okuzokwenzeka ngoba-ke kuzofanele ukuthi-ke noma-ke abasejele noma abaphethe ijele babe khona-ke bathole nabo ithuba lokuthi bayiphendulele kulezo yinsolo lezo ezikhona kuleyo ncwadi leyo. Kuzofanele futhi-ke ukuthi kwenziwe ngendlela-ke okwenziwe ngayo ngaphambilini ukuthi-ke kusheshiswe ukuqula noma inqubela phambili yecala. Futhi-ke akunyakushilo ukuthi-ke nenkinga-ke ukuthi nginganikezwanga ithuba lokuthi ngiphendule ngoba namuhla-ke noma kusasitshelwe inkantolo ngaphambilini ukuthi kuzofanele ukuthi-ke siphenduleke kuloko kuzobe kubhalwe uyena ummeli wakhe ummangalelwa wokuqala noma labo abane. Kodwa-ke ngiyayixolisa inkantolo ukuthi angizange ngikwenze lokho ngoba-ke akunalutho engakuthola engangizophendula kukona. Ngicela-ke ukuthi inkantolo nasiphi esinye isicelo esizothi senziwe-ke namuhla inkantolo ingasinaki ngoba siyazi ukuthi namuhla besizele nje okubili kuphela indaba yokuthi icala liqulwa kuphi khona kule nkantolo kanye futhi-ke namadokodo amabili. Akukho neyodwa-ke kuloko noma kulezo-ke eyenziwe. Bese ngicela-ke ukuthi inkantolo-ke asikho isizathu sokuthi inkantolo ihlale futhi ilalele-ke nasiphina esinye isicelo ngoba inhloso yanamuhla-ke akusaqhutshekwa ngayo. Yimina-ke umuntu osaqhubeka-ke ebuza ufakazi. Ngizocela-ke ukuthi inkantolo icala ilihlisele i-4 zikaSeptember ngize ngibe ngiyaqeda-ke ngaye ufakazi okhona la enkantolo. yabe simtshela-ke inkantolo advocate umsholo lokuthi-ke ayikwazi-ke ukuthi ingalinaki udaba oluvezwayo-ke lokuthi ukhona-ke impilo yomunye wabamangalelwa esengcupheni. Inkantolo-ke ayifuni uma ngabe-ke ukuthi uma sekuphinde kubuywa-ke kubuye sekuthiwa-ke ukhona ongekho ngoba ukhona oshonile. Inkantolo ayingeke, yebo noma ngabe inkantolo ingavuma ukuthi incwadi ayifundweke, kodwa ngeke ithathe isinqumo ukuthi-ke kuzokwenzekani noma akwenziweni-ke ngalokho okubhaliwe kuleyo naleyo ncwadi, inganikezanga ithuba abasejele noma abaphethe ejele ukuthi nabo bazoyiphendulela kuleyo ncwadi.
Yes.
Yes, thank you, Your Lordship. The copies are done. I distributed to both my learned colleagues, the state and accused number 5. And there is a copy for the court. I think I'll be in their hands as to how long do they need to read the letter. Then they will guide the court. Thank you, Lord.
As a court, please, my lord, I've just perused the letter. My suggestion, my lord, would be that perhaps we can stand down the matter so that we discuss it with correctional services as we've done in the past, and they've been very cooperative. That would be my suggestion, my lord.
I agree with the state, my lord.
Your Lordship, the copies have been done for the purpose of this letter to be read, as it was a humble request of my accused number 3. It cannot be that after the copies were done, now there is a somersaulting now. Let the matter stand down. We are going to consult with the authority. Because it was in response to Advocate Mushololo. The court said, I would not. The court said it's not amenable to ignore. This happened to be serious allegations. By our own judgment, as the accused 1 to 4 counsel, these are serious allegations. We cannot afford to defer them to the next time, which we don't know. There is no justice that is happening to my client, to accused number 3. And in our maxim, in terms of the law, it says justice delayed is justice denied. My client is suffering. And I can feel this excruciating pain on his behalf. It cannot be felt by Mushololo. It cannot be felt by Waloi. That's my due diligence, where it comes, that I persuade this honorable court to humbly, and humbly so, accede to the request that the letter be read. We are not saying, Your Lordship, after the letter would have been read, we are not saying the court should issue order. The court should do something. We are saying the court may hear the conditions under which this accused number 3, who happened to be before this honorable court, how he has been made to live a daily life in prison. It's not about that accused number 3, Your Lordship, is asking that Hoshimampuru be changed into a 17-star hotel. He is not canvassing for that prison be a hotel where we live in comfort. He's saying, I'm suffering. And more so, he has been transferred from Johannesburg prison to this prison where he is complaining about the conditions, that he was never subjected under this condition while he was still at Johannesburg prison. So this is what he's asking. And he does have a local standing insofar as his complaint is concerned. He does have a jurisdiction because this court is the one that is presiding over his trial against him of such a serious allegation.
He has jurisdiction.
This
You mean
court,
accused number 3.
this court has got jurisdiction to hear. Thanks for correction. So he himself, he does have a local standing, and the court has got a jurisdiction to entertain his complaint. Is it correctly corrected, Your Lordship?
Let's proceed. Let's proceed.
Thank you. This is my submission, Your Lordship. We don't agree with deferring this matter to another next time. Because this, as I said, there may not be next time. It's possible. The condition under which we are living in these days, as the court has correctly said, the pathology events coming in and out at the correctional centers. It's my humble plea that may the humble cry of my client, accused number 3, be heard in this court today before it's too late. Thank you.
My Lord, what the state had in mind was that we adjourn perhaps until 2 so that we can get in touch with the head of prison, bring this to their attention, and for them to see is there anything that they can do to assist in terms of what is permissible and what is not permissible. And in that way, my Lord, I think we'll be, addressing the real issues and not just merely listening to the concerns. So I would suggest that maybe we take an adjournment and the matter is taken up with the head of prison and we can then report back.
I'm also asking myself if in the event where you don't get the relevant people who are authorized to provide you with what you need, given I haven't seen the letter because I haven't heard any of you saying that you consent to the letter, to the court being exposed to that letter. But to the extent that it has to do with the well-being, if not the safety of the accused, especially accused number 3, to the extent that you may not achieve that, I propose that we look at an interim position where accused number 3 may be incarcerated anywhere. I hear all the time when Advocate Tefo rises on this point, I hear him mentioning a specific prison. And I have a problem with that because I don't think people awaiting any trial should have a choice about that. But equally, I am concerned about the nature of the issues being raised, being the safety or the survivor, if I may put it that way, of an accused person. So to the extent that I want to agree with what you are saying about an adjournment for arrangements, to if it were to be that you still don't have a position, there should be an interim arrangement about where accused number 3 will be incarcerated until the complaint is given attention.
As a court pleases, it will be one of the issues that will canvass, with them as well.
Udaba olungayo ummangalelwa wesithathu ke umshushisi uyacela ke noma bekunesicelo ke sokuthi ke nanjengoba beqeda unikezwa ke amakhophi umshushisi kanye naye ke ummeli kammangalelwa wesihlanu babheka ke noma besafunda ke incwadi ke ukuthi yini ebhaliwe kuyona ke babe sebecela ke ukuthi nje bacela ke umshushisi ucela ukuthi bakhulumisane nabo ke abengamele noma abaphethe ke ejele sizobuya ke noma sibuye ngo2 kuzobhekwa ke ukuthi ke yini ke isixazululo esingakhona ke uma ngabe singatholakala ke isixazululo ileso ke isicelo esenzwa uyena umshushisi ukuthi ke okwamanje ke bafisa nje ukuthi bakhulumisane nabo abaphethe kulona ke ijele leli ummangalelo wesithathu ke athi ke akaphathekile kahle kulona.
Yes, please, Court, Your Lordship. This proposal or mentality from the side of the state to say, let's first hear the present authority before this letter could be read. I knew the contents of the letter myself. So previously, when the request was made, I was given that opportunity to approach accused number 3 to find out from him if is he amenable for any of my colleagues to lay his or her eyes on the letter. He's more than willing, as long as at the end of the day the contents can be read to this court and the court here. So now what will be, I'll be wondering, as per the state's proposal, that now they've got the copies. He wants the matter, the court to adjourn so that he can canvass the contents of the letter, which he don't even know. The court never heard about them. Then he discussed with the present authority. What are you discussing with the present authority for something that you don't know? I was thinking that
If the court makes an order, will it not be the prison authority that has to carry out that order?
at the moment, Your Lordship, we don't know how, after the letter may be read, we don't know how the court is going to react towards this. The reaction of the court, because one thing for sure, the court has to react towards these contents. So we may not know how so. And it's not what we are saying that the court must act according to the letter or according to the concern of the complaint. And it's what also was said by Mshololo. What's surprising also, that you don't know the contents, but you don't want this thing to be read. And this person is not your client.
So
How-
you will not want the court to act. You just want the court to hear there's a letter, these are the contents.
You want the letter to be read to the court? And then?
It ends there.
No, I'm not. I say, one thing for sure.
No, you did say it won't require the court to act.
To act.
Yeah.
That's what I say.
Yeah.
And I want
act
to.
is to make a ruling.
I want to.
Or to decide on the contents of the letter.
This is the allegations, and I want to qualify my allegations to you. Because the way when you say court, we mean you, Justice Mohammed, isn't it? Am I right?
Proceed.
Thank you. We call you. You are a judge. You are a court.
Did I,
And the
do
court
I
is a
need to be
human.
reminded about that? Huh?
The court is a human being. The court is a grandfather. The court is a father. The court is a husband. The court is an uncle. The court is a human being. There's no way, Justice Mohammed, you cannot react after you heard this, if that opportunity to read this is given. If you cannot definitely react, I don't know what I'll tell myself. And my great-grandson, after I've gone in this world. that at one stage I was before this court, never reacted, never feel anything, never had a feeling.
What are you talking about?
No, what I'm saying is that one thing for sure, if this letter can be read, the court will definitely say to the state, is there no way that something can be done? Only after it would be read. Not now that Baloyi will talk to someone that he doesn't even know what he's talking to him about. So it would be a waste of time to stand down until 2 o'clock and then Baloyi talk to someone, prison authority, for something that he doesn't know. So I'm humbly trying to...
So if this, because I want to be very clear.
Yes.
So if this doesn't find agreement, you agree that we will leave matters as it is and look at the next coming date for this case? Because because you heard what I said to Advocate Baloyi.
After the letter would you have read?
I mean, if you don't agree, if the three of you don't agree about, because he wants it his way, you want it your way. If you don't agree and the court does not make any ruling which removes anybody from any prison,
Okay.
you will be content that we leave matters like they are, because part of what I wanted is an exploration about what alternatives can be resorted to before this matter is given full attention. And I don't know if the prison authorities, for argument's sake, are guilty of anything. I don't know why you would be so afraid of them being told that you are accused of this and this and this as against number 3.
If the prison...
So you are predetermined that they should not hear about it until the court will have made some ruling, which cannot happen.
The prison authority are well conversant with the content of the letter. Because when you read, because myself, I had that opportunity, it says, the first line, it is on record. Blah, 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 the whole content is on record before this court. It's on record at court. So now, when...
you are saying Advocate Baloyi should take your word for it, where that is concerned.
At one stage, it was not made, Your Lordship. There has been, even during that time, this court has been saying, I'm unable to act against the prison. I'm unable to make an order against prison.
Yeah.
Initially,
Yeah.
I'm taking the court back.
Yeah.
And according to me, it was like the court was giving the concern or the complaint of my client the cold shoulder. You see, of course, as for Baloyi,
Well, that's your view. All I said is...
That's my allegations.
Yeah, that's your allegation. That's
Yeah.
your misguided allegation that I'm unconcerned. Because even this morning, I was telling you, actually my statement was the history of this country and its prisons and all those activities tell a story, and it is that story which is motivating me to disagree with the approach held by your colleagues. But that is, I'm not here to justify myself. What I'm saying is that, are you saying if you don't agree, because if you don't agree, then there won't be any argument going on. We'll then go to the next date. And I said, for saying that, I said I should be armed with something. I would be doubtful, I would be unsure of ordering that he goes back to the very same situation which may be in that letter, which I have not yet read. That's all I'm saying. And if you are happy for things to happen that way, all the same, you are his legal representative. We can as well close where we will have disagreed, and everybody goes to where they came from this morning.
Yeah, that's what I want to try to avoid. And I was about to say, insofar as the court is talking about the agreement of 3 of us, I don't see that why should be a disagreement, disagreement and that will persuade the court to say, let the status quo remain. Because naturally, this is a criminal matter. We are in the criminal proceedings. My client is accused number 3 in a very serious matter of alleged murder. And then Advocate Baloyi as the state, he does not have a feelings. He doesn't care. Because this accused number 3 is a criminal to him. Let him suffer. Let him pay what he has done. Because my client has been called with all sorts of names in this country, whereby we've got the presumption of innocent. So, insofar as Advocate Baloyi is concerned, I'm not even concerned about it. He can, I don't want to repeat those words of previous time. He will argue until the goats come home. So, as for the argument of the state or the opposition of the state, I'm saying it's natural. You have to bring that, but it does not have substantiation. He cannot substantiate this argument. So, but if it's within the persuasion of this court, insofar as the state is concerned, for which I never heard this state making a very reasonable and very concerned substantiation or submission to this court to say why I'm opposing this. He's opposing this for the sake of opposing it, to say this is accused, I'm against him, and my authority. My bosses must see that I've been in court, I've been defending the state. Whichever thing that Defo has been saying in relation to his client, I've been there to defend. Whether my defense has got the substance or not, I will just defend for the sake of defending, because I'm the defender.
As a court, please, my lord, my learned friend has said scurrilous and gratuitous insults, and we have given him all the opportunity to say what he wants to say. We are here to try and address the issues raised. We could have made progress. He's been addressing the court for the past couple of minutes. We could have put a call through to prison and see how we can address the issues. It will take us absolutely nowhere if we see the whole day and listen to the complaints. We're trying to perhaps find a practical solution to address the issues that have been raised in the letter. I suggest that perhaps we adjourn at this stage. Let's see how we can accommodate accused number 3.
We will adjourn now, and the following will happen.
Kuzokwenzeka lokhu ke okulandelayo ke manje.
The 3 of you shall confer and seek common ground. If you do not, do explore an intermediary alternative about the whereabouts of accused number 3 until this issue is fully attended. The reason why I'm saying so is because I have been made to believe that the issue, whether founded or not, has to do with the survival or otherwise of one of the accused. And that is why I insist on that. And I did say before that the history of this country taught us that these things have a way of happening the way that some of the inmates allege. I also have experience of some inmates falsely claiming same to have happened, which is why each time it happens, both sides have to be heard and a proper decision has to be arrived at.
Indeed, my lord.
Now, none of the claims should be brushed off the table. None of the denials should be brushed off the table, but they should be fully attended so that the court can be best informed in making any ruling. And that is the reason why I'm saying, after you confer, if you don't agree, please explore a possibility of an intermediary position whilst this is given attention. If you continue to be in disagreement, the prison, which will have noted that there has been an interference by the court, albeit on an intermediary basis, will decide what to do, whether to come and put whatever record straight if they think there's a record not straight, or to leave matters as we are and we continue with this trial.
Indeed, my lord, that is all that we are suggesting, my lord.
So sizobuya ke ngo-2
Yes, Mr. Court.
inkantolo ngenhloso yokuthi ke bazokhulumisana umshushisi nabameli uzanye ukuthi ke kuthola ukuthi singatholakala yini isixazululo ubone ukuthi kungenziwani ke ngesimo sakhe ummangalo wesithathu.
As the court pleases, my lord, we are indebted to the court for the indulgence. My lord, we did bring the letter to the attention of the head of CMEX, Mr. Mashabataka, as well as the area commissioner. Both of them are here, my lord. And in terms of the privileges that are requested in the letter, they've indicated that they are unable to meet accused number 3 in terms of those privileges.
You should remember, I haven't seen.
Yes, I'm aware, my lord. And I've indicated to Advocate Stifo that perhaps we should hand a copy of the letter to the court, and I think subject to correction, confirmation by Advocate Stifo, he indicated that we can hand up a copy to the of the letter to the court. We will just have to agree as to how the evidence will be placed before court.
Yes.
Can the letter then be handed up formally? I don't know whether it will be necessary to give it an exhibit number, but given that it's an ad hoc issue, my lord, I don't think it's necessary to burden the record with further documentation. We will then allow the applicant to bring his case, and thereafter the state will then call the head of prison.
Yes. Yes, Mr. Advocate Defo.
Yes, Lordship. I can confirm, Your Lordship. I can call upon accused number 3 to come in the stand.
Yes.
Lordship, indeed, I met with Advocate Valoi. We were at his office during this adjournment, and then whatever he said, I hereby confirm. And now I will direct my attention and the attention of the court to accused number 3, who is in the box now. He will have to explain his situation, and that will be interpreted. And then where the state witnesses, being the prison authority, having disagreement, they will relay that. Thereafter, having had both sides of the applicant and the state and the prison authority, then the decision will be made by this honorable court. I hope it's in order, Your Lordship.
Yes?
Thank you. Carlos, you'll have to explain this court.
Yeah, you can say.
Igama lakho nesibongo mfethu.
Mthobisi Prince Mncube.
Thobisi Prince Mncube.
Do you have any objection in taking it this that oath?
Uyimisela ukuthatha isifungo noma khona okuvimbayo ukuthi uthathe isifungo?
Hayi anginanto.
No objection.
Do you swear that the testimony you're about to give is the truth, the whole truth, nothing else but the truth? If so, can you raise your right hand and say so help me God?
Uyafunga ukuthi ubufakazi. Stop. Uyafunga ukuthi ubufakazi ozonikeza ngabo lana buzoba iqiniso lodwa futhi iqiniso eliphelele mangabe kunjalo phakamise isandla sakho sokudla uthi inkosi ngisize ngikhuluma iqiniso.
Ngizongisiza ngikhuluma iqiniso.
Thank you.
Before you lead him, I have this letter here, and I have quickly gone through it.
Yes.
And I want to hope that you are not going to lead him to repeat what is in the letter, as opposed to us going the route we were going, to have this letter read into the record, and then checking whether you have anything to add on it.
Not at all, Your Lordship. What's going to happen, it will just be that, as he's the author himself of this letter, and you know his problem that he's encountering. I'll just say then the rest he will just elaborate.
In that case, will somebody read the letter into the record?
So that somebody will be me, Your Lordship. And on behalf of the applicant, Your Lordship, I will just apologize, as is a layperson, for demotion, calling you your his worship. In actual fact, your lordship. I put my neck on the block on his behalf. I've got a thick neck. To his lordship, Mr. Chifiwa Maumela, the Honorable Judge, North Gauteng High Court, Pretoria. Dear sir, subject, court case number CC 67/20. I am the accused in the above matter presently before this court. I write to bring to the attention of this court and further place on record the inhuman condition under which I am being incarcerated, which conditions inevitably adversely impact on the fairness of my trial in the above criminal matter. By virtue of my incarceration in Pretoria C-Max prison, I am barred from listening to the news and current affairs, and from receiving books, newspapers, etc., etc. I'm daily incarcerated in solitary confinement for a minimum of 23 hours, allowed only 1 hour exercise, allowed for 5 minutes calls per month to my family because the phones used by inmates have been broken since last year, October, and are still unfixed, which makes it difficult for me to contact even my legal representative. I'm held in mechanical restraint. Once outside my cell for any reason, including going to visit I tried to request the head of center for at least a radio, and that he allow us to buy food from the shop, because the food we are getting is not fit for an adult person or for human consumption. But he never even responded to my request. It been almost a month since I have requested. Under the circumstances in which I am presently incarcerated, it has become near impossible for me to concentrate on my ongoing trial for an alleged crime, in which regard my right to a fair trial will be breached should this court continue with hearing of the above matter, whilst I remain so incarcerated. It was accepted by the court in State versus Zwelibanzi and other. (2005) open brackets 2 close brackets 2 SARC South African Criminal four 484 Eastern Cape matter, that the concept of a fair trial is not only limited to what happens in court, but includes the situation where the accused is unable to give the required attention to the trial due to distracting factors, including difficulties experienced with his accommodation, etc., etc. My daily incarceration in solitary confinement for a minimum of 23 hours is in clear disregard of the relevant provisions of the Correctional Services Act and the South African Bill of Rights. Furthermore, there is no provisions in Correctional Services Act which condones such inhuman treatment as I am daily subjected to. Being indigent and further faced with matters of a more pressing nature, I'm unable to approach a high court to seek redress. The Correctional Service Department blatantly breach of my rights in Section 12 and Section 35, subsection 2, paragraph E and F, and Section 35, subsection 3 of the Constitution, and thus hereby respectfully ask that in the interest of justice, the court intervene. Respectfully yours, Mtobisi Prince Mumude. This is the contents of this letter, Your Lordship. Ozuyele Prince.
You understand?
Yeah, myself, whatever.
Yes, although I'm not good with English, but yes, I heard.
So, are you consciously relate yourself with the contents of this letter?
Uthi-ke ngokuphelele wena-ke uyihlanganise nalokuyana kubhalwe laphayana amagama ukuthi kuphuma kuwena.
Yeah, uphuma kimi.
That is indeed correct. It comes from me. That is the court.
Yeah.
Yes, sir. Would you want this to be interpreted to you wholly.
Ngaba ufisa ukuthi le ncwadi ke uyihunyishelwe ngokuphelele noma uyitolikele ngokuphelele le ncwadi eqeda ufundwa manje?
Yebo, ngidolele.
Yes, you can interpret for me.
Do you have the same?
No.
Can I take a seat, Your Lordship, while in the meantime the letter has been interpreted in Zulu to the applicant?
Yes.
Bhalwe amagama akho laphayana phezulu nokuthi ke useHoshimampuru khona la ePretoria eCMEX Center. I-date ile yanamuhla ke 12 July 2022. Futhi ke incwadi ke ibhalwe kuyena ke uhlonipheki ujaji. Ngiwumangalela kuleli cala leli ke elichaziwe lana ke liuCC 6720 phambi kwalenkantolo. Ngibhala ke ngesifiso sokuthi ngilethe noma ngazise kulenkantolo futhi ke izimo ezingekho zinhle engivalelwe ngaphansi kwazo futhi ke nezinomthelela ekuthini ke ngingabi noma ke umqondo wami ungabikho ngokuphelele ekubhekaneni necala leli engiphambi kwalo enkantolo. Ngokuvalelwa kwami ke ePretoria eCMEX prison ngiyavinjwa ke ukuthi ngilalele indaba futhi ke ngilandele nalokho okwenzekayo nokuthi ngithole incwadi, ngithola amaphepha noma amaphephandaba nokunye. Futhi ngivalelwa ke njalo ke ngivalelwa ngingedwa isikhathi esingangamahora awu-23 la ngivunyelwa khona ke ihora elilodwa lokuthi ngilolonge noma ngi-exercise imizuzu emine noma emihlanu yokuthi ngenze noma ngishaye ucingo ngenyanga ngishayela ke umndeni wami ngoba ingcingo ezisetshenziswa yiboshwa zaphulwa ke noma zophulwa kusukela ngonyaka ondlule ngo-October futhi ke ayikalungiswa kuze kube manje okwenza ukuthi ke isimo sibe nzima ke kumina ukuthi ngixhumane noma ngixhumane ke nommeli wami uma ke sengingaphandle ke eseleni sami noma ngasiphi isizathu noma ke ngiphumela ukuthi ngizobonwa ngizamileke ukuthi ngicele ukuthi owengamele ijele ukuthi nje ngithole noma ke i-radio nokuthi azivumeleke ukuthi siyothenga ukudla siyokuthenga esitolo ngoba ke ukudla
This cell phone is making sound for the second time, if I'm not mistaken. Can the owner and the phone go out, please?
ukuthi ke siyothenga ukudla ezitolo ngoba ke ukudla esikutholayo ke ngaphakathi ke akona ukudla okusesimeni ukuthi ke kungadliwa umuntu kodwa ke akakaze nje aphendule kwisicelo sami futhi ke sekuyinyanga ke manje ngasenza leso sicelo leso phansi kwezimo ke engivalelwe phansi kwazo angikwazi ke ukuthi ngathi ke ngibhekisise ngokuphelele icala futhi ke namacala lawo ke engibethwesiwe futhi nokuthi ke icala lami ke ngilihambe noma ngililalele noma ngililandele kahle. Isinqumo ke esathathwa yinkantolo kwicala lakhe uZwelibanzi kanye futhi nabanye ngo-2005 to SACR la kushiwo khona ke ukuthi umangalelwa ke ukuze ahambe noma icala lakhe ke alalelisise noma liqhubeke ngendlela efanele ibhekwe ke lokho okwenzekayo enkantolo kodwa ke lokho kufaka nesimo la khona ke umangalela engakwazi ke ukuthi abheke noma ahambele icala lakhe kahle noma kungekho nje okumphazamisayo ngokufanele noma ngokuhlangana nendlela athi avalelwe ngakhona. Ukuvalelwa kwami ke ngivalelwa ngingedwa futhi ke isikhathi esingamahora 23 lokho ke kuyatshengisa ke nje ukuthi kutshengisa ngokomthetho wezasemajele kanye futhi ke neBill of Rights. Okunye futhi ke nesibonelelo ke sakhona e-Correctional Services Act esiphakamisa ke ukuthi indlela noma izimo ezifana nalezi ayivumelekile. Ngicela ke futhi angikwazi ke ukuthi ngiye kwinkantolo ephakeme futhi ke ngidlulise lona ke lecala ke noma ngichaze bona ke abakwa Correctional Service Department ngendlela ke abenza ngayo ukuthi ke amalungelo ami angifanele ngingawatholi ngendlela abangivalele ngayo. Wasubhala ke ngaphansi igama lakho uMthobisi Nqubo.
Thank you. Therefore, as you have said, and it has been read to you in the language that you better understand and understood. Therefore, can you explain to this court which human rights, which of your constitutional human rights, as yourself being accused, incarcerated in that place you have mentioned, are being violated, and how do you need to be resolved, the lack of better word to say.
Nanje ngoba ke incwadi lena isifundiwe ke ngolimi noma ngolimi oluzwayo noma lolu ke olukhulumayo futhi usuchazileke la nimaphi ke uma wena ke ungayisho lo ngawapha amagama noma ngawapha amazwi ke lamalungelo akho ke othi ke iwona ke ongawatholi futhi ke isiphi isixazululo noma ufisa ukuthi ke ingaxazululwa kanjani le ndaba noma lo daba.
And I will allow you the opportunity to go freely without being hindered. Then I will take a seat.
So vumela ukuthi uyiphendele nje ungaphazamiswa. Ungaphendula.
Hayi lesimo ngiphathi kwaso lapha mina sinzema kakhulu esayidini lami. Ngoba manje ngihamba icala ngapha ngikhoni cabanga kahle ngendlela efanele ngoba manje
the situation that I find myself in is a very difficult one, a lot, because on the one side I'm attending to this matter and I'm unable to think properly.
lapha uhlala wedwa
Asilinda bhala.
Proceed.
Okay, maqhubeka.
lapha uhlala wedwa selini mohlala wedwa lapha isikhathi eside kakhulu uphuma 1 hour ye-exercise ngapha akuna radio akuna TV akuna lutho nje khona la.
There you are in solitary confinement. You only go out for an hour to go to exercise. There is no radio, there's no TV, there's just nothing.
Well, that sounds like a repetition of what is in the letter.
Yes,
I don't see the use of adducing that evidence if we agree that this letter has been read into the record. I thought whatever he has to say might be in addition to what is in the letter.
I'm sure ukuthi inkantolo ayifisi ukuthi iphinde lokhu okulana ngoba ibekwe ilokho isidingo sokuthi kufundwe inkantolo yazi ukuthi kubhalweni la so ungaphindi ke inkantolo icabanga ukuthi ngozoma kwakho lana ke uzosho okunye okungekho khona la ungaphindi ke lokho sekufundiwe ukubhalela.
Okay.
All right, thank you, Lucy. Before you get incarcerated at Khoshimampuru, were you ever at any correction center by chance?
Ngaphambilini kokuthi ke uzovalelwa ke khona la eKhoshimampuru ke khona ke enye nje ijele noma correction center la owawukuyona.
Yebo ngoba ngiza lapha ngisuka eJohannesburg prison.
Yes, before coming here I was at Johannesburg prison.
When were you in Johannesburg prison first time?
Okokuqala ke wawuse Johannesburg prison nini okokuqala noma uqala kwakho base Johannesburg prison kwakunini?
Since 2015 May 9 February.
Since the 9th of February 2015.
Ngangisetrial ase-Johannesburg prison.
I was awaiting trial at Johannesburg prison.
Nge-2017, nge-27 July.
Okay.
Ngagwetshwa ngagwetshelwa futhi ngahlala khona ejele lase-Johannesburg prison.
And then on the 27th of July 2017, I was then sentenced and I remained at Johannesburg prison.
Were you sentenced in the same matter or different matter?
Ingaba ke wagwetshwa kwelinye icala elahlukile kule noma kule cala.
Hayi ngagwetshwa ecala elinye elahlukile.
It was in a different matter.
Into ekhona nje kuleli isibhama bathi.
All right, sure. No, just let him confine himself to the question, to the leader.
Uzocelwa ke ukuthi ulalele lokho okubuzwayo ubusuphendula lokho
Yes,
okubuzwayo.
yes. I'm satisfied with that. Is different matter. And then, as you were sentenced to serve in Johannesburg prison, were you serving your sentence where? Was it in the solitary confinement or in the communal section?
Emumva kokuthi ke wase ugwetshiwe ke wagcinwa khona lapho ke eJohannesburg prison. Ingabe ke nalapho wawukwisele la uhlala khona wedwa noma ke wawula undawonye kanye nabanye?
Hayi bengihlala nje kwi-community cell, ngihlala nabanye abantu.
I was at the community center. I was with other people.
Then how was the present condition in terms of, or insofar as the exercise is concerned?
Isimo khona lapho ke sasinjani ke ngokuphathelene noma
Compared to where he is now?
sasinjani ke isimo khona lapho eJohannesburg prison uma ke usubheka ke usuqhathanisa noma ke na la ukhona manje sasinjani ngale isimo
In terms of exercise?
exercise.
Besikhawunta ekuseni besivulele uma beqeda ukusikhawunta. Baze basivalele mase kuvala ntambama.
They would count us in the morning, open for us, and then they would take us back and lock us up later in the afternoon when we go back.
How many hours were you given in Johannesburg for exercise?
eJohannesburg ngaba nani nikezwa ke wawunikezwa noma nani nikezwa amahora amangaki ukuthi ni exercise?
Noma ngingazo babe besivulela ngabo 7 soze sibuyele ngabo past 2.
Although I wouldn't be able to know, but they would open up for us around 7 and they would lock us back around 2.
So now, in comparison, that was the way in which you would wish to be treated as compared to here.
Uma usuqhathanisa ke indlela ke leyo ubungafisa ukuthi ke kungangayo uma ngaba usubheka esala isimo ukhona manje. Ungafisa ukuthi kunga njengalesa simo leso qedwe usisho manje saseJohannesburg prison.
Yebo.
That's correct.
Were you allowed the reading material in Johannesburg?
eJohannesburg ngaba bebenikeza ke izincwadi zokufunda.
Hayi incwadi ziyabe ngena
Own food there.
Ukusho ukuthi suphoqelekile ukuthi udle okwabo ukudla kuphela.
yeah.
That's correct.
Are you allowed the chance here to take care of the health insofar as in Johannesburg? Were you able to do your washing?
eJohannesburg ngaba bekuvumela yini ukuthi washing
Clothes.
ukuthi uyigezele ingubo zakho zokugqoka?
Yebo bengiwashe.
Yes, I did.
Do you do the same here?
Uyakwenza lokho la?
Cha.
No.
Were you allowed to visit in Johannesburg by
eJohannesburg
your family, relatives, and
Yes.
your lawyer?
eJohannesburg babekuvumela yini ukuthi umndeni wakho ummeli wakho beze bazokubona?
Yebo bebese.
Yes, they used to come.
Did the same happening here?
Ngaba lokho kuyenzeka yini la?
Hayi la kuyenzeka kawu-2 ngenyanga nakhona ufika 30 minutes umuntu wakhona.
Here it happens twice a month and the person only be allowed 30 minutes.
So the general treatment of Johannesburg prison, insofar as your individual person is concerned, incarcerated person and sentenced person, can you say the difference as to where you are now in comparison?
Isimo sakho ke noma sendlela ohlala ngayo eJohannesburg nanjengomuntu ke owayegwetshiwe ke ungachaza ke ukuthi ke sehlukile ke kunalesi esala ukhona manje.
For example, are you married?
Ushadile?
Angishadile.
No, not.
But you are stable. Partners. Une partner.
Yebo mna.
Yes, I do.
So, and you've got the children.
Neyingane unazo?
Yebo mna.
Yes.
Yeah. So the typical example that I want to bring for your understanding is that, let's say, a child is not doing well or a child is sick. While you are in Johannesburg, would you get that courtesy of being given the message, personal message from home about the well-being of your family? And then compare that to here.
Asithi ke nkathi use Johannesburg bekunesimo la khona ke umntwana engaphathekile kahle ekhaya. Belikhona ke ithuba lokuthi lo mlayezo ke uthole noma ke usuka khona ekhaya kumndeni ke uchazelwe ke ukuthi kunesimo esikanjena umntwana akaphathekile kahle uma qhathaniswa lokho nala ukhona manje.
Hayi bebe ngikhona ukuthi ngifone everyday ngoba kunamafoni ama-public phone.
There I was able to make a call every day because there were public phones.
La ngihlala khona ama-public phone awekho.
Where I am currently at, there are no public phones.
So that response, actually, you are telling this court to say, I was in touch with the outside world in Johannesburg prison, as compared to here in Kosimampuru, whereby I've been distanced from the reality of the world.
Okushoyo ke ukuthi nkathi use Johannesburg prison ke ubukwazi ke uxhumana nalabo abangaphandle kodwa la ngikhona manje eKhosimampuru akwenzeki lokho.
Hayi khona kunzima la ngoba ngisho nje ingane zami akazange ngixhumane nazo since kusukela kwanyaka odlule.
Here it's very difficult because I haven't been in touch with my children since last year.
And how do you feel when you don't get to contact with your own family?
Lokho kwenza uzizwe kanjani ke uma ngabe ungakwazi ukuthi uxhumane nomndeni wakho?
Ngihlukumeza kakhulu ngiyangilimaza nasemqondweni that's why ngingakhoni nokuthi ngifocus eqaleni ngoba manje ngihlala ngicabanga kakhulu ngezinto ezenzeka ngaphandle.
It's very much hurting and it's also disturbing me, which also results in me not being able to concentrate on that which is happening here because I think a lot about what's happening outside.
This place where you have been incarcerated, they are called correctional services. Let's go back to Johannesburg prison. Would you, when you explain to this court, say indeed Johannesburg prison was correctional service? There were attempts to correct me so that the day I get out of that prison door or prison gate, I'm indeed a corrected person. I'm a new person. As compared to the person that came in here, as compared to where you are now.
La ukhona ke noma uthi uma ngabe sekubiza noma igama abalisebenzisayo ukuthi kule correctional service noma correctional center noma la aqondiswa khona ke igwegwe. Uma ngabe uthatha le ndawo ke kanti futhi nase Johannesburg ke ungathi uma ngabe uphuma khona lana uthi impela bengisendaweni la khona ke bengizoqondiswa khona ke futhi nanje ngoba ngiphuma nje ngiphuma impela ngiqondile.
ayi kunoshintsho kakhulu ngoba le ndawo iwenza ube nanenhliziyo embi kahle kahle.
There's been a huge change because this place makes you have a hardened heart.
Makes you evil.
Hayi wenza ube nenhliziyo embi nje kahle kahle kushuthi nje.
Just yes,
Umuntu oyidelile.
just an evil heart is someone who just looks down upon himself.
What is your plea to this honorable court insofar as this situation? All right, before I come to that one, then how did you come to be removed from Johannesburg prison, the place which it was trying to make you a better person?
Kwenzeka kanjani ke ukuthi uhanjiswe noma umikiswe eJohannesburg prison indawo ke eyayizama ukuthi ke ikwenzeke umuntu ongcono. Kwenzeka kanjani ukuthi ususwe khona?
Biba ngitshela nje ukuthi bangithatha ngoba nakho ngivukele icase ka Senzo Meyiwa.
I was just
Thatha bangiletha la. Okunye ngikwazi ukuthi.
okay. I was just informed that I was being taken away because now this case of Senzo Meyiwa has come up against me, and now they are bringing me this side. I don't know anything else.
Who is that person who broke that news to you?
Ubani ke owakulethela lezo indaba?
Amaphoyisa la afika ngoba ngifike la nge-4 December 2020. Iphoyisa lase Sun City lafika ngesonto nge-6 ngoba ngalali babengangithathelanga u-8 lebazi bakuthatha sengikhona la bafika ngesonto.
It was the police. I got here on the 4th December 2020, and the police arrived there on the 6th, it was on a Sunday, the 6th of December 2020.
Babezothatha usigroup wami la bathi angena ngo-A group eSimex.
Okay, they came to take my A group because they said that you don't go into CMEX with the C group. Ushone?
Kungenwa ngusigroup eSimex.
Or into the CMEX you go with the C group, not with the A group.
Can you just explain to this court to understand those dynamics of the correctional services?
Awuchazele lenkantolo ke ukuze ikuzwisise kahle ke kuloko kushoyo manje. Ukuthi uthini?
Open prison. Kuno A group, no B group, no C group.
Okay, bambe lapho ke. In open prison there's an A group, a B group as well as a C group.
B group uthola uma ukuthi mhlambe uyifeda charge into kanjalo.
Zama ukuthi B group, it's where maybe you have some further charges. Yebo?
C group uthola umuntu mhlambe ngithi wenza amacala asejele.
And then with regards to the C group, it's someone who committed an offense or offenses inside prison.
La ngihlala khona kuno B group no C group.
Where I am, there's B group and C group.
So, you said in maximum you are taken on the basis of when you are categorized under B and C group. That's how it happened that you find yourself in maximum today.
Uthi nanje ngoma uyithola use maximum manje ngoba ke maximum ke bathatha uB no C.
Maximum kuno B no C la eSimex.
In maximum here in CMEX there is B and C.
Simex kodwa maximum open prison ino A B C.
But in maximum where it's open prison there is A B C.
Where are you now?
Ukuphi wena manje?
It's close maximum.
Close maximum.
Where you talk about the category B and C.
Ila kuno B and C khona.
Yeah.
Yes.
So, you have been incarcerated on a different matter, on a different case. You are J70 signed to Johannesburg prison, am I correct? Initially.
Nawu njengoba ke ugwetshiwe elinye icala futhi uma ngabe sekusayindwa ke i-J70 yakho isayinelwa eJohannesburg prison noma ikhomba eJohannesburg prison ngabe kunjalo?
Yeah.
Yes.
And then, when you were taken, or by any chance before maybe this, your transfer, were you by any chance being categorized as a B group or C? Both of them,
Johannesburg.
Johannesburg.
Ngabe ke eGoli noma eJohannesburg prison ke ingaba bona ke baba wawukuluphi ukuhlu wawuku B noma wawuku C?
Angiku A.
A.
Okay. By the way, you didn't explain A. What is A? Because B does when you've been sentenced, then it happened that you've got another case that is still under investigation. And then C, that's when you become a villain yourself. When you are already in prison, you are committing crimes within the prison. You are already sentenced. So now what's A?
Umchazile ke uB kanye no C, uA ke yini yena?
A ma usuhlala 6 months ejele uqeda ugwetshwa uhlala 6 months kuyahlukana ngegwebo wesinye unyaka emva kwalokho sebekunikeza A group.
Okay. A, it's after having been sentenced and it's after 6 months, about 6 months, and then it also differs based on the sentence that you are serving, and then you are then given the A group.
All right. When you were taken from Johannesburg prison, insofar as you are concerned after the sentence, you said earlier that you were in a communal cell. So, was there any, which would it be, was there any pending case that was still under investigation against you after the sentence? And secondly, in terms of the C.
Nkathi useJohannesburg usuqedile ke ugwetshwa. Mama ngam usuzwile ukuthi isigwebo sakho sithini. Ingaba kukhona yini olunye uphenyo lelinye icala owawubhekene nalo ngemuva kokuthi usuthobe isigwebo? Ukhona elinye icala olaziyo elalikade liphenywa ngawe? No, there was no pending case or no investigation.
Okay. By any chance, in terms of category C, while you were there and before you were taken, or at the time when you were taken from Johannesburg, did you commit any crime within the prison?
Kathi ke useseJohannesburg prison njalo ke ngaphambili kokuthi uhanjiswe ulethwe khona la ePitoli ngaba khona yini icala walenza khona phakathi ejele usejele?
Ayalikho.
No, I did not.
So, if that is your answer, then your incarceration in maximum in Hosimampur, was it correct? Because you are not falling under B, you are not falling under C, but yet you are taken in the caption for which you don't belong to either of that category.
Uma ngabe kunjalo ke ngale mpendulo oqeda unikeza manje ke kusho ukuthi ke indlela ke noma uhlobo ke ovalelwe ngalo khona eHosimampur ukuthi le ndawo bakufake kuyona nje bakufake kuyona ukuthi akusiyona indawo ekufanele ukuthi ukuyona.
Yebo kunjalo.
That is indeed correct.
Okay. And when you are taken from one prison or one correctional center to other one, there are procedures that have to be followed. And very tightly so. In terms of the provisions of Section 43 up to 45 of the Corrections Act, before you could be transferred to another correctional center, you have to be examined by the medical practitioner. Did that happen?
Kunenhlelo ke noma khona ke imithetho ke ekufanele ukuthi iyalandelwa ke ngaphambilini kokuthi uthathwe ususwe kwijele elithize uhanjiselwe kwelinye ijele. Ufanele futhi ke ubhekwe ke noma uhlanganeke nodokotela ke akubheke ngaba kwenzeka yini kwesaphi isimo lokho?
Esensithi bangibuza nje ukuthi ngithatha treatment noma kwenzakalani ngathi cha ngithatha treatment.
In Sun City, they only inquired from me as to whether I was taking any treatment. I then said, no, I'm not taking any treatment.
Yeah, but that question isn't that related to if someone is with an allergy, so that they can know what kind of the food or how do they treat you? It's not in relation to the provisions I mentioned.
Lowo mbuzo ke ngabe akusiwona ke umbuzo nje la abafisa ukwazi ke khona ke ukuthi mhlasimbe khona nje nokuhluphayo une allergy onayo noma khona nje ukudla engakufanele nje ukudle. Akusiwona umbuzo ophendula lokhu mina ngikubuza kona ukuthi wahlanganiswa yini manje ngoba umthetho ke usho ukuthi uma ususwa kwelinye jail usiwa kwelinye kufanele ukuthi bakuhlanganise nodokotela.
Yebo bangithatha bangisa eclinic la Sunset.
Yes, they took me to the Sun City Clinic.
Before they transfer you.
Ngaphambili ukuthi bakulethe la.
Same day ngalelo.
Yes, it was on the very same day.
They just approach you and take you to the clinic, but without in detail explaining the purpose of that exercise.
Ingaba bavele nje bakuthatha bakuhambisa bakusa eclinic ngaphandleni kokuthi bakuchazeleke inhloso yokuthi yini imbangela ukuthi bakuse clinic.
Abangithatha nje bangisa eclinic lapha bafike bangibuza nje leyo nto leyo yabo. Mase ngiphuma bangitshela ushifa selokuza Sunset udinga yes.
Okay. They only took me to the clinic and then they asked me that, and thereafter the chief or the head of Sun City informed me that I was going to CMEX. Captain. Okay, he's saying now the captain.
When was that?
Kwakwenzeka nini lokho?
May 4 December 2020.
It was on the 4th of December 2020.
Were we having the COVID on the 4th of December 2020? Were we still having the regulations?
Statement, the question.
Ask.
Okay. Ingaba ke sasise phansi kwemithetho ke elawula yona ke iCovid ngaleso sikhathi leso.
Yeah.
Yes.
So, on arrival at the Kosimampuru, where the regulations of the COVID followed in terms of taking you to the observation cell for 10 days, that hospital section.
Ingaba ngathi usufika ke khona ke khona la ePitoli eMkhosimampuru ke ingaba bayilandela yini imithetho yayo ke iCovid ukuthi bakuthatheke bakusekwisele la khona ke uyogcina khona ke amalanga awu10
At the medical section, hospital section.
Kule section ke yasesibhedlela.
Hayi ngafikela nje sectionini ngafika ngahlala kuyo. Ngafika leselini ngahlala kuyo.
No, I just went straight to the section where I was kept. I went to the cell.
That's where you are still staying there.
Uselapho namanje.
Sengisukile sengihlala kwenye section.
Now I've since moved. I'm now in another section.
But what you are telling this court is that you have never been taken for the observation, or there is a word, Your Lordship, when you're coming from America, you come to South Africa, you don't mix with the people. Quarantine, yes. So, were you ever quarantined? That section, was it meant for the quarantine, or you were just kept there?
Ingaba nje bakuthatha noma bekuthatha nje begcina khona lapho noma ke masasebenzisa ke lona igama lesilungu ukuthi quarantine khona.
Abangithatha nje ngaya kwenye section.
No, they just took me to another section.
That's all that I needed this court to know. Or before I finish, is there any other thing that you want to tell this court?
Khona okunye officer ukuthi ungakutshela lenkantolo?
Yebo akho.
Yes, there is.
Kufika lapha nge 4 December 2020 ngafika ngashawa ngingazi ngangishawelana.
On my arrival there on the 4th of December 2020, I was assaulted, and I don't know the reason why I was assaulted.
Ngachokwa nangogesi le-shield le ugesi.
I was even electrocuted with the shield, electrical shield.
Ngaso sonke isikhathi hlala sigadwe ngazo lezi izinto lezi ama-shield.
At all times when we being guarded or looked after, we are guarded with those shields.
And ngiphuma ngesela every day ngifaswa ngey'nsimbi.
Each and every time that I am going out of the cell, I am like cuffed with irons.
Ngathi uma ngibatshela ngendaba yokushawa kwami lapha ngibuza ukuthi bangishayelani.
When I informed them about me having been assaulted and also inquiring as to why was I assaulted,
Bangibuza ukuthi ngishawe ubani.
they wanted to know as to who assaulted me.
Emva kwalokho kusho ukuthi sengihlele khona lapha bonke umuntu obengena lapha uyashawa ngabona ukuthi umthetho wakhona hlahla wonke umuntu uyashawa mayifika la.
And whilst I was now there, seated there, I would see that now each and every one or each and every person, when someone comes in, every person gets assaulted. So I just saw that, oh, this is how they operate. They just assault anyone or everyone.
And nje impilo yakho inzima owesinye isikhathi uthi uhleli nangu umuntu uyakhala ngale seleni bamchoka.
And the life there is difficult because you are just seated there and then you are hearing someone in the cell is crying, that person is being choked.
And umphathi makangena ebusuku isikhathi esiningi nokungena ebusuku aya-check-e mawuthi uyamtshela umphathi yena uthi akayazi leyo nto.
And then the person who is in charge usually comes in at night to come and check. And when you inform that person about that, he will just say, no, I know nothing about that.
Lokho nje ukungiphazamisa kakhulu ngoba manje angikhoni nje uconcentrate esini.
It's that, my Lord, which is disturbing me, and as a result of that, I'm unable to concentrate on the matter.
So the present authority will tell this court that the reason you have been taken to maximum is because you've been assessed, you've been actually identified as that category to belong to that because you are a dangerous person.
Uzothi ke osebenze ejele ke noma uma ngabe seza ke zonikeza ke ubufakazi noma esezochazela lenkantolo ke uzothi isizathu sokuthi ithathwe leso sinqumo ke sokuthi usiwe khona lapha yana ukuthi kwathi uma ngabe usubhekwa ke kwabonwa ke ukuthi ke ufanele noma kulungeleke ukuthi uhambe uyogcinwa khona ngoba nje ulo muntu nje onobungozi.
Hayi mina lokho angikwazi lokho.
I know nothing about that.
That's all, Your Lordship. Thank you.
We shall have a 5 minutes adjournment.
Let's please the court.
Yeah. Today, we have had evidence from accused number 3 in this case. There were debates in the morning, and we ended up with accused number 3 testifying as he did, and as should happen in every case, if a person testifies under oath, it gives the other parties the latitude, if not the right, to cross-examine, which is where we should have been. It would have been where we find out whether Advocate Mchololo and Advocate Baloyi should, that one of them should cross-examine. The debate this morning, with regard to which I even differed with Advocate Mchololo, was about the relevancy of what we have just heard. I had a choice of allowing this to unfold forwards and knowing that it would be something near a charade sold to accused number 3 and everybody that is concerned in this trial. I have firmly decided that I cannot go that route. What propelled me from this morning is that I was made to understand that there are ongoings in prison which affect accused number 3, which have potential to threaten, if not to take away his life, if not his safety or well-being. I think his well-being is grievously affected, and if you wake me up in my sleep and ask me about it, I will say maybe this should not happen that way, but it's just me hearing about accused number 3 who is awaiting trial in a case before me. Most of what the testimony went about has nothing to do with the issues that are involved in State versus Sibia. And I also remember now that it seems to be a repeat, because this was canvassed at the beginning, and I think I said something which I'm going to say again today, that the matter has to do with the way prison authorities are handling accused number 3, if not even more accused than just accused number 3, whilst this case is underway. And back then, I impressed it upon Advocate Tefo that if that be the case, then he should take it up in court, number 1. If not, with the prison authorities, if he chooses to do so. But the impression he gave me today is that they may not even listen to him. But the issue, once they have not listened to him, the question is whether that matter comes onto this bench in this case. And thinking that I had right when I came under the impression that he is either being subjected to torture or assault, which is ongoing, which is threatening his life, other than the assault he claims to have received when he first arrived at Kosi Mampuru. I felt that I cannot go and have a good night's sleep knowing that there is a person under such conditions. over and above that, all that accused number 3 was testifying about, which I want to believe he has a right to voice, and about which I believe he has a right to be heard, has nothing to do with the case before us. When I said this at the start of this trial, I remember, if I'm not forgetting anything, that advocate therefore even told us that he will go to court to assert the rights of his clients. I even, in my understanding, I could have misunderstood him. In my understanding, I thought that he means that he's even prepared to launch an urgent case against the prison authorities, in which he will be asserting the rights of his clients to be observed. The circumstances of the incarceration of accused number 3 are double-fold. He is in custody because there is this case that is unfolding against him and others. Secondly, my understanding is that he is serving some sentence for a case. I even said back then that let us not delve into that, because before me, accused number 3 is supposed to be innocent until proven guilty. When I tried to assert that this morning, the retort was that his rights, the rights of accused number 1 to 4, will be suppressed if he is not given a say. And being a human being myself, knowing almost from first hand what happens in our places of incarceration, I felt this has to be given attention. Now I have given that attention. After giving that attention, nothing has been forthcoming that would justify me delving into it and coming up even with a ruling. It has to do with what happens to prison, to convicted inmates, what happens to awaiting trial inmates, of which I want to believe there are protocols that are relevant to that, and it's either they are being followed or they are not being followed. The tinge of relevance that I find is only that, to the extent that whatever is happening, it is affecting the ability of accused number 3 to master a formidable defense in his favor, because he is not together, he is not able to concentrate. That is cause for concern, but should it be a matter for this bench now in this trial? I think if it is a matter to be attended to, it will not be within these proceedings. And when I had way back Advocate therefore almost threatening, if not promising, to be in court about it, I said within myself, ride on, brother, you are on the right route. And only for this matter to now emerge the way it did today, and like I said, I should have been allowing Advocate Baloyi and Advocate Mshololo to decide what they do about the evidence given, but it will be in all honesty, it will be parading a charade before everyone, and it will be giving false hope even to accused number 3, to make him think that after it all, I will have something to say, and which is not the case. I will not have anything to say about the prison conditions. For what I know, they must be just, they must be in line with the law, they must be constitutional. If they are not, if he has a legal representative, that legal representative must do something about it as in yesterday. And as a result, I am not going to have this matter unfold further the way it is doing before me, because after it all, I will have nothing to say. I will be better informed about what he is experiencing. I might even sympathize with it. I might even scream against it, but that's the furthest I will be able to go. And therefore, with accused number 3 having testified the way he did, I am not even going to listen to cross-examination by Advocate Baloyi or Advocate Nchololo. I'm directing, as I do now, that this matter be relayed to the correct channels, even if the accused number 3, because there is mention in that letter about the ability or the wherewithal with which to challenge his situation. If he is not able to fund his protection against those circumstances out of his pocket, there are other avenues to get legal representation. But I would even urge whoever is responsible for his affairs to make sure to approach the prison, to approach court so that the prison authorities may be called upon to respond, to confirm whether he was telling the truth, or even to challenge it and prove it to have been untruthful, what he was testifying about. So as far as this so-called application today, which is not even an application, it's a letter that was written to this court. All I can say is my sympathy, but no thanks. I cannot make a ruling on it because it is not my sphere, it is not my periphery. It has not come before me in a way that I can be called upon to make any ruling on those issues. And whatever was mentioned about approaching court before, if I were anybody that was asked, I would say that should be the route to go. And if I were to be asked whether it is correct to have anybody in solitary confinement, I would say out and out it is inhuman, it is unconstitutional, but that's all I can say. It's my comment about solitary confinement. Having said that, the proceedings today, as far as the application is concerned, end here. I am ordering that we stop with what we were doing because it won't be useful and it won't produce any useful outcomes.
Counsel, mfethu sithathe isikhuma ngako konke bese kwenzekile ke ngoba ngendlela ke ulitshelwe ngayo ekseni ke ukuthi isimo lesi ke bekuyisimo esibucayi kakhulu futhi esibeka impilo yakho engcupheni. Kodwa ke emuva ke kokuthi ingakho ke nenkantolo isithatha isinqumo sokuthi ayivume ukuthi le ncwadi ifundweke. Kodwa ke kubo bonke ubufakazi obethulile la enkantolo akukho nje okushoyo noma okuvezayo ke noma ubufakazi obushoyo ukuthi impilo yakho ngempela isengcupheni ngokumayela nokushaywa-ke ukushaywa okhulume ngako yiloku othi kwenzeka ngaleli langa elilodwa ngathi ufika khona laphayana-ke indlela yokuthi-ke abasemajele-ke baphatha kanjani-ke abantu abagwetshiwe nabangagwetshwanga-ke le nkantolo ayikho-ke kwisimo sokuthi-ke ingathatha isinqumo okungakusho nje ukuthi uma ngabe kwenzeka lokhu yazulana nakho kodwa ummeli wakho nanjengoba futhi kubhaliwe encwadini ukuthi bazoya enkantolo-ke iyona ndlela-ke leyo efanelekile ukuthi aye enkantolo noma idluliswe-ke futhi uma ngabe ungakwazi-ke ukuthi ungakhokhela ummeli ukuthi-ke usebenzise-ke abe-legal aid-ke ukuthi kube yibona-ke abakusizayo kodwa inkantolo-ke isithatha isinqumo sokuthi-ke lolu daba lolu-ke ngeke ibisanikezela umshushisi ithuba lokuthi akubuze imibuzo kanye naye-ke u-advocate umsholo ukuthi nje le nkundla yanquma ukuthi-ke lolu daba lolu luyaphela khona manje lana emuva kokuthi ithe yalalela ubufakazi bakho obethulile.
As it please the court, Your Lordship, thanks for indulgence. As I've indicated this morning that I will address this court. That's in relation to what has happened insofar as the case number 3 is concerned, that's how far my contribution can be. It's now opportune moment, Your Lordship, to inform this court that as the counsel of case number 1 to 4, I hereby inform the Honorable Court that I'm withdrawing as the counsel of case 1 to 4. I will no longer be able to proceed in this court based on the harassment that I'm receiving from the state and from the court. The accused have been consulted and it has been agreed upon that based on what is happening to me, because I took it upon myself that I will represent them after I was approached, myself and my attorney, by their families as well as the Meyiwa family. At the time when I was approached, together with my attorney to represent case 1 to 4, I was the watching brief on the Meyiwa family insofar as case number 2 is concerned. 375 of January 2019. I will therefore retort back to my role as a watching brief of the Meyiwa family as appointed by Sifiso Meyiwa, the brother of the late Senzo Meyiwa, on case 375. Insofar as 636 is concerned, I'm a human being, Your Lordship. I've got the emotions, I've got the feelings. I deserve and I demand the respect. Not the demand of the respect per se. If I respect you, I expect the respect from you. That's where my demand is coming from. Because the respect is the reciprocal. It's not one way, it's two way. Give and take. The reason, Your Lordship, I can no longer be able to be in court and face you, there are serious allegations here, whereby you are accused number 1. Before I can even accept the case of 636 to represent the accused 1 to 4, there has been harassment that I should not be part of this case. From the police, from the NPA. I came into this case knowing what will be the consequence. On the 28th of April, when I was arrested before your court, Your Lordship, that was a plan. And the plan was hatched in the office of the President, the number one office of the number one in the country. That I'm a problematic advocate. I'm interfering with a plan that has been hatched, that my client should take the responsibility of the murder of Senzo Meyiwa, despite the fact that they were innocent. So,
I'm sorry, my lord, and I don't want to be rude to my learned friend, but we suggest, my lord, if my learned friend is going to withdraw, that he should just do so, my lord. I think it's unfair to malign institutions or you know, or other persons, my lord. I don't think it's proper. The people who don't have the opportunity to defend themselves.
now,
my lord.
Mr. Valoy, I'm the one withdrawing. Can you sit down?
Yeah, but can you talk about withdrawal? I've heard
Yes.
I have part,
Is it
I've been
proper,
part
Your
of
Lordship,
harassing
that
you,
when I talk about
and I'm
withdrawal-
not going to listen to you on end.
What
You
is
are
proper?
withdrawing. You're part of the reason why you are withdrawing is because I am part of your harassment.
Yes.
Yes. And anything else?
No. Can I be allowed to say what I have
No.
to say?
No.
I don't have to say.
Yes.
I don't have that right to say.
You don't have.
I must
the
just say
right-
I withdraw.
You don't have the right
I must just say I withdraw.
to be irrelevant and go on end. You have carried the message. You are withdrawing. You have conveyed the reason behind your withdrawal. I am not prepared to listen to anything else.
It's not about this, whether you listen willingly so. That's the decision that
I
you take.
I am unwilling and I am not going to.
All right. So let me just say that. But maybe you are right. Let me just say that.
Yeah.
Now is the opportune moment to inform this court that I'm withdrawing
Yes, you have done that. You are repeating it.
as the representative, former representative of the
Yeah.
accused 1 to 4.
Yes.
Thank you.
Ummeli ke bechaza ke izathu ummeli ngammangalo lokuqala kuyofika kuyena ke owesine ukuthi ke akasaqhubeki ke noba ummeli wenu kulona ke lecala uyishilo ke izathu ila khona ke shuwa ukuthi ke angabeki ke izathu kodwa nje asho nje ukuthi yena akasaqhubeki nalo icala ikona ke lokho bekudlulisa ke angeke ngezisho ke ngoba inkantolo ayivumanga ke ukuthi kube izinto ezikhulunyana noma aqhubeka ukuthi azisho enkantolo kodwa nje ukuthi ke anise naye ke ummeli.
Advocate.
Your Lordship, before you come, in relation to what we submitted, Section 6, that as it has been agreed, the party, the state, and the
Are you
accused 1
are you
to
still
4.
part of the case? I thought you withdrew.
No, can I be allowed to finish?
No, you can't
Say-
withdraw. It can't be riverbank. No, it doesn't go that way.
I know you don't want to hear what I'm saying. You
Yeah,
sound
I don't
patient.
want to hear anything anybody says who has withdrawn. I don't want to.
Yes, fine, it's on record, it's you.
Yeah.
Yeah.
Advocate Baloy. The advocate therefore is withdrawing, is announcing his withdrawal from the case.
Yes, as the court pleases, perhaps to first deal with the ruling that was made by the court regarding the evidence of accused number 3. Must say we have the same concerns, my lord. During the adjournment, I had a discussion with Advocate Mshilolo, and we're going to raise the same issues. I also conferred with correctional services, and we agreed that the right procedure would have been by way of motion proceedings. So we were going to raise that aspect as well, my lord. And secondly, as far as the withdrawal is concerned, my lord, the case, as I mentioned this morning, has been postponed to the
Let me hear Advocate Mshilolo first before we go to the postponement date. Withdrawal?
Withdrawal, no, I have no objection, my lord. I accept it as the court pleases.
Advocate Baloy?
The matter has already been adjourned to the 5th of September. Now, obviously, accused number 1 to 4 will have to indicate what the plan is going forward. I suggest that maybe the matter be provisionally postponed to a holding date, so that on that date, accused number 1 and 4 can indicate what the plan is going forward, and maybe we can then take it from there.
Do you have an idea about the date?
We will have, in light of these recent developments, we will have to phone the office, my lord, to get a date.
My lord, I have a small suggestion here. Since the matter is a partly a matter, that we continue with the reserve date, which is 5 to 16. And I'm hoping that in the meantime, accused 1 to 4 will be able to secure the attendance of their legal representative should they choose that. And then those legal representatives be given these dates as the new dates as the return dates for this matter, so that we don't lose these dates, my lord.
I also don't think we should lose the days, but I think to ensure that I don't want to come here on the date we are envisaging to find out that nothing has happened. That prison has not allowed anybody to consult anybody, or things like that, like those. I think the route of consulting with the DPP and at the same time making sure that if there's somebody who is coming on board, they are in a position to proceed on the date we are going to be here in September. I think that is the safest, rather than just to think of the date in September, which may not bring the outcomes which are amenable to this case proceeding forward.
If that is the case, my lord, I would suggest that we give a provisional date for the confirmation of legal representation.
Yes, remember what also should happen is that there should be transcription. Whoever is to come on board.
We have already requested the transcript, my lord. Through this day.
Has there been progress?
Yes, my lord, we submitted the request sometimes in June, and that was on around the 14th, the 15th of June, with your secretary, and she did confirm that she will arrange that.
Okay. Maybe that will have to be followed up.
Yes, we gave her the dates.
Do you know anything about it?
Yes, we did get the request for the transcripts.
Okay.
May I be excused, Your Lordship?
Well excused. Advocate Tefo, you derobe once you are out of the court. You don't derobe here before me.
Apologies.
The one alternative, my lord, is to identify a date on which this court will be sitting, and if the date is suitable to Advocate Nshololo, we can then postpone it to that date without further reference to our office.
Can you repeat that?
I was just thinking that if perhaps there's a date readily available now on which this court will be sitting, we can simply roll this matter to that date if that date will be suitable to Advocate Nshololo, and we can always arrange that maybe she be excused because she will not have much interest in that aspect of the legal representation of accused number 1 to 4.
Okay.
We can just get a provisional date
I
on which
think
this
any
court is
date,
sitting.
if we choose a Tuesday or a Wednesday, 3 weeks from the third week into the next coming term. I think that will, because in any case it will be just to check the coast with regard to possibilities of continuing further in this case.
Okay. Perhaps if we can just adjourn for 2 minutes, the court can wait in the corridor. We can just quickly sort it out between ourselves.
So we should have excused you. You can go back. You say for how long?
Just about 2-3 minutes, Mulati.
Okay. Please rise. Accused number 1 to 4, you were in court. What was being said ended up with your legal representative, Advocate Therefore, withdrawn.
Benikhona-ke enkantolo uma ngaloqala kufika kwesine-ke nixwile lokhulunywa enkantolo okwasepholela ekuthini-ke ummeli wenu engasaqhubeka ukuthi animele.
The legal representation is a right enshrined and at your disposal in terms of the constitution of this country.
Ngokomthethosisekelo-ke wala eNingizimu Afrika-ke ukuthi nibe nommeli kuyilungelo lenu.
You even have the right to be prepared, and prepared in this context will mean that you should get a lawyer if you choose to get a lawyer, or you should choose to represent yourselves going forward. And if you choose to have another lawyer, you should be able to consult with that lawyer before we proceed.
Futhi-ke nelungelo lokuthi nilungiseleleke ukuthi uma ngabe nizofuna omunye ummeli noma nizoyimela-ke kodwa uma ngabe nithatha isinqumo sokuthi nifuna omunye ummeli kufanele ukuthi nihlale phansi-ke nikhulumisane ngalo icala leli lokubathi-ke uconsulta nalowo mmeli loyo omusha enizomthola.
And for that, we are postponing this case to the date you had been mooted, being the 2nd of August 2022, so that in the meantime arrangements should be made, and I think I will urge Advocate Baloy to do all necessary for that to begin to happen, so that when we are back here on the 2nd of August 2022, there will have been progress. Otherwise, in any case, they should by then be having a legal representative, and that legal representative should be put in a position to be able to acquaint themselves or himself with this case if it will be the route of another legal representative.
Okuzokwenzeka-ke nanjengoba senizwileke ukuthi ilanga-ke kuzobe zi-2 ku-August noma 2 kule nyanga ezayo-ke kuwona lo nyaka miselwa sona ke leso sizathu ukuthi ke uma ngabe nithatha isinqumo sokuthi nibe nommeli omusha ukuthi abe khona ke futhi inkantolo isibhekise kuyena ke uadvocate Baloyi ukuthi alekeleleke ukuthi enze isiqinisekiso ukuthi lawo malungiselelo ke ayaqala ukuthi ngalelo langa ufanele ukuthi abe sele ukhona ke ummeli uma ngabe kuzobe kuyisinqumo senu ukuthi ke nizofuna noma nizofisa ukuthi nibe nomunye ummeli.
Having said that, something I said at the beginning of this trial, your right to legal representation is not absolute. It has to find its place amongst the rights of others.
Ilungelo lenike lokuthi nibe nayo ke ummeli kufanele ilungelo ke ukuthi ekufanele ukuthi litholeke indawo noma kwamanye amalungelo akusolana nje ilungelo elilodwa kodwa ke kufanele lithole indawo kumanye amalungelo akhona.
In other words, if we go overly long without you getting another lawyer, it may happen, I'm not saying it shall happen in this case, it may happen that weighing up the rights of others who are involved in this case, we may even proceed with you unrepresented.
Inkantolo ayisho ke nilalelisise kahle ukuthi lokho kuzokwenzeka noma kuzoba njalo ke uma ngabe kodwa kuthatha isikhathi eside ke ukuthi isikhathi sesiyahamba ke akatholakala ummeli noma anibi naye ummeli kuzofanele kubhekeke amanye amalungelo akhona abanye abantu nabo ke abambandakanyekayo kulona lelicala lokho kungasho ukuthi ngafanele ukuthi icala liqhubekeke engekho ummeli kodwa ke inkantolo ayithi ukuthi yilokho okuzokwenzeka.
You had me addressing Advocate Baloyi because I expect him to bring the prison authorities up to speed to the reality that you may require another legal representative, and if that happens, you may require consultation with your lawyer or lawyers.
Nizwile ke inkantolo uma ngabe ikhuluma ke ibiza lona ke igama lakhe uadvocate Baloyi izathu ke ukuthi ke mase nifikelele lapho ukuthi ke batholakala abanye abameli noma omunye ummeli lokho kuzosho ukuthi ke kuzofanele ukuthi yena ke akhulume nalabo abaphethe ejele ngoba loyo mmeli noma labo bameli kuzofaneleke ukuthi bahambe baye lana igcinwa khona ke beyokhulumisana nani.
Even with all that has taken place, the position is still that all of you, including accused number 5 who has his legal representative here, you are still regarded as innocent until proven guilty or innocent as you are now.
Nonke ke njengoba nimi phambi kwale nkantolo kanye naye ke umangalo wesihlanu onommeli ongowakhe ke phambi kwale nkantolo inkantolo isanibona ke njengabantu ke abamsulwa ke noma abangenacala ke kuze kufinyelele kwisinqumo ekuzofinyelela kusona emaphethelweni noma kuthiwa isinqumo la kuthiwa khona necala noma aninacala kodwa phambi kwale nkantolo nazi ukuthi le nkantolo akukho kushintshile kuko konke okushiwo namuhla inkantolo isanibona njengabantu ke abangenacala noma abamsulwa ke.
Do you understand?
Kuyezwakala konke lokho bafethu nizwile konke lokho kushiwo inkantolo nonke understood my lord.
Do you need clarity on any aspect?
Kukhona enifisa ukuthi nje inkantolo imchazele kona enicabanga ukuthi nje anikuzwisisi kahle kukhona la nifuna ukuthi nicacele khona ikhona nje into mhlasimbe enicabangayo noma nifisa nje ukuthi ni
especially accused number 1 to 4 because they are now on their own.
Inkantolo ikhuluma ke futhi umangalo lokuqala wesibili wesithathu wesine ngoba ke aninammeli njengamanje so ikhuluma nani ke isikakhulu kukhona nje okunye khona nifisa ukwazi nifisa ukuqona
mina baba ngiyakuza ukukhuluma enkantolo lokho ebhekisa kuphela nami njengoba asho number 2 angani uma ngivulele ethi ngandlulisa isikhalo sami angikho enkantolo.
As accused number 2, I don't know whether I am entitled or whether the court would allow me to just to raise my consent to the court.
I wish I could. It's 4. By 3:30, you should have been out of here. But I heard what you said.
Inkantolo iyafisa ke ukuthi ibingakulalela ke uma isibheka isikhathi ke manje seku4 bekufanele ukuthi 3:30 bekufanele ukuthi seniphumileke manje khona la kule ndawo enikuyona-ke kodwa inkantolo iyakuzwa-ke lokho okushoyo.
It may mean that you'll do that through a lawyer if you'll get one. If not, you will do that when we are back here on the 2nd of August.
Kungenzeka-ke ukuthi lokho uzokwenza uma ngabe-ke kungenzeka-ke ukuthi njengoba kuzofakwa isicelo ukuthi nithole ummeli noma abameli abasha ukwenze lokho ngommeli lo ozomthola noma-ke ngaleli langa leli icala elihlehliselwe lona 2 August lokho ukuzokusho-ke manje ngicabanga ukuthi ngenxa yesikhathi-ke inkantolo manje isisaba ukuthi-ke sesikhulume into ngoba isho ukuthi bese kufanele ukuthi besenihambile uzozenzela lokho uzokhuluma ngey-2 zika-August noma umuntu nommeli yena-ke uzokusho lokho ekushoyo wena. Thank you, my lord.
Having said that, this case is postponed with the accused in custody. The postponement is on a provisional basis. It's postponed to the 2nd of August 2022.
Lihlehliswa-ke icala lihlehliselwa-ke umhla we-2 zika-August lihlehliselwa sona-ke izathu leso inkantolo ibisisishilo ngaphambilini. Siyabonga-ke.
Anything else?
That is all, my lord.